there was a knock at the door, and it was two of John's coworkers standing at the door with tears streaming down their face. And they said, "John is gone."
When somebody goes to work, you expect them to go home the next day to their families, and when that doesn't happen, it rips your heart out.
Most important is rescuing, is saving lives. We're going to do whatever it takes to get you out.
Whether they're victims of a crime or they're suspects of a crime, usually they're crying out for help, and we're there to help them.
Trying to catch bad guys is my attraction to it.
I always wanted to help out those that couldn't help themselves or that needed help.
First responders, they put themselves in harm's way every day.
So they really don't recognize what they do as being special. It's just the job, and it's what they signed up to do as a profession.
Honestly, I've been doing this 22 years next month. I've only been scared one day, and that was my very first day on the job.
And realizing that it is dangerous. You're not invincible. It could be your last day, last call.
This is the last call for number 1328, fire engineer paramedic Mark Carter off of the engine 37A shift, who is now on scene at Greenwood Memorial Park. Good night, engineer paramedic Carter. Rest in peace. 1311 hours, KOA 519.
They got into a shootout, and he was the first officer in, so he was the first one killed. I just want him to know that his father loved him more than anybody, that he was the reason he came home every night. It's hard to have a life without somebody when you're just starting out, when you're that young, and you have a lot of dreams and a lot of hopes, and they stop, and there's nothing that you can do about it.
He always did this with our son, the older son. He hugged him, kissed him, and gave him a caress, and he told him he'd be back. I wish I had told him just one more time, I will always love you.
Rob was responding to an accident at a major intersection. Lady made a left turn. She was headed in the other direction, and she made a left turn and hit him, and his vehicle spun and hit a light post and exploded.
Anytime an officer is killed, it's a tragedy.
I just don't like to dwell on things like that, because I don't want to think about it. I really don't.
Probably should think about it as far as planning ahead.
Or you hear about people who don't have a will, and then if something happens, their kids are in limbo, or who gets them, or who gets custody.
I don't think anything can replace a firefighter that dies in the line of duty. The next worst thing is not being able to help the family, not being able to help the children or the wife get on with their lives. That just knocks the wind out of you.
The will is for those that are left behind, because they are the ones that have to deal with all the legal matters and all the, the estate of the person who loses their life.
I'm 52 and never had a will. I think that's, shame on me.
Wills for Heroes program provides the wills, the durable power of attorney, the living will.
They're just making it too easy, the accessibility, and the big thing is it's free.
These lawyers are sort of our legal angels, as they give us the guidance and give us the wills to take care of our family and make it absolutely painless to do.
It's not really for you, it's for all the people that have to deal with your mess afterwards.
I think one of the misconceptions is that it takes all day. It doesn't. It took me 45 minutes and I was done, and I could not believe that there was no charge.
If Wills for Heroes wasn't here today and this opportunity didn't present itself and he didn't know about it through work, we'd still be talking about doing it. I'm here to tell you.
8 years from now.
We would not be it wouldn't be done. We'd have the conversation every week, but it still would not get done. So now it's done. And if something happens on the way home today, my kids are taken care of. I don't have to worry about it anymore.
Thanks everyone for coming this morning to our Wills for Heroes program and everything you need to know to volunteer for our Wills for Heroes program. A couple of thank yous before we get started. I want to thank Dan McKenna and Carolyn Capobianco, Mary Beth Scanlon from our Ballard Spar office in Philly for marshaling this program, marshaling the foundation, and Tyler Cobb here locally for setting this event up, and really the executive leadership of Ballard Spar for supporting Wills for Heroes as they have done for so many years, and for its unwavering commitment to pro bono. This video is really being produced thanks to Ballard Spar, so we're grateful to everything that the firm is doing. So, I'm Jeff Jacobson. I started the Wills for Heroes program 11 years ago in Arizona. To my right, the camera's left, is Denise McLean. She's with Abbott Downing. And on the end is Tricia Baggs with the Wells Fargo Private Bank. Collectively, we have over 30 years of experience with the Wills for Heroes program. This morning, we're just going to get started with Estate Planning 101, and I'm going to turn it over to Tricia and Denise for that part of the seminar.
Why don't you go ahead and start with why we volunteer for Wills for Heroes.
Sure. So I feel like I should look at all of you. Hopefully that's
and I think that's what we're just going to do for the video. I mean, we have an audience that's right here, so we'll be talking to you and occasionally looking forward to it.
So I'm Tricia Baggs, and currently I'm with the Regional Wealth Planning Team for the Wells Fargo Private Bank. But previously, I practiced law at Quarles & Brady and Fenimore Craig as a trust and estates attorney. So when I first heard about the program, it was a great fit from a practice area perspective, but also I married into a first responder family. So my husband is one of 4 brothers. The oldest is the battalion chief for Scottsdale Fire. The next is a sergeant for the Mesa PD. Next is a patrol officer for Huntington PD. And then there's my husband. He's a lieutenant for the Chandler Police Department. So I thought, what a great fit. We can help those who help us in an area that I know a little something about.
And I got involved because Tricia and I worked together when we were over at Quarles & Brady. And she told me about it, and I adored Tricia and her husband, and heard about what we'd be doing in the program. And I love spending Saturdays volunteering and also working on the training. So I also did trust and estates practice. I'm at Abbott Downing now, which is a wealth management group. That's also part of Wells Fargo. So Tricia and my paths have gone from Quarles & Brady, and now we're back kind of under the same umbrella. But it's a pleasure to come and to train folks on not just estate planning, but what we're going to do for the firefighters and the police officers. And it's, with all volunteer work, you go into it, you're excited to do it. And every time I go, I leave on a complete high. And the thank yous that are coming from the other side of the table. Oh, thank you for doing our will. Thank you for doing this. I'm thinking, you run into buildings on fire for us. You're putting your lives at stake for us. This is the least that we can do. So it's really awesome to do. So what we're going to do is we're going to start off with giving the overview of estate planning. And we call it 101. This is not going to have you, set up a new practice area and take on estate planning. But we want you to have the overall, just kind of the broad brush of the landscape. So if people are asking you questions, that you can be answering those questions. But also know that every time you're doing a Wills for Heroes event, there's a site coordinator, and there's somebody who's usually in the practice area of estate planning. So you can always just raise your hand, and we're right there to step in. So with that, why don't we jump in on our agenda and get going?
Sure. So we already probably skipped the agenda and just dive right in. We're going to cover the basic elements of an estate plan, and let's just jump into that and start with the durable power of attorney. A durable power of attorney, also known as a financial power of attorney, is a document under which you can name an agent to make financial decisions for you if you're unable to make those decisions yourself. So if you are incapacitated to any degree, to the extent that you can't make financial decisions for yourself, then your agent can step in and make those decisions for you. Without this document, your friends, your family, your loved ones would be forced to go into court if you are incapacitated and you don't have a financial power of attorney in place to get what's called conservatorship in Arizona, to get control of your finances. So with this
fairly straightforward document. You can give authority to someone in your life to make those decisions in the event you can't make them for yourself. Now, there are two types of financial power of attorney documents. There is one that's effective immediately and one that's effective upon your incapacity. We call that springing. So you'll see as we go through the questionnaire that the clients you'll be meeting with have the option. Do we want to make this effective immediately or only if upon incapacitation? You might be asking yourself, why would I ever make this effective immediately? Because that gives immediate authority. So I tell my husband, Sean, you have immediate authority. You can go sell our house without my permission. You can go take out another mortgage without my permission. As you can imagine, as people age, it makes more sense for them to have power of attorney effective immediately so that their kids can take control without proving they're incapacitated. For younger folks who are more healthy, typically you'll see these to be springing so that the agent does have to prove incapacity. And in our documents, it requires two physicians to certify that the person is incapacitated. So you'll see that option, but the folks you'll be dealing with will be younger first responders in most cases, or even you won't be meeting with elderly folks where we would typically see this apply for immediately effective, but we'll cover that in more detail when we go through the interview. Okay, so the next document, healthcare directives. We've combined two documents in our healthcare directives. There's a healthcare power of attorney and a living will. So like the durable power of attorney, the healthcare power of attorney is a document where you name an agent to make decisions about your healthcare. So if you are incapacitated, the physician knows that he or she can't rely on what you're saying, you're not able to make decisions or you can't communicate those decisions, then your agent can step in and make decisions as simple as, do we use generic or brand name prescription medication, or up to including end-of-life decisions. So your living will provides guidance to your healthcare agent. If you are in that situation where doctors determine you're brain dead, you're not going to recover, you're in a terminal condition, you leave directions to your agent about what steps you would want your agent to take or what things you would want your agent to refuse. So this is the end-of-life decision. Should your agent refuse or remove life-sustaining treatment? If you think of the Terry Schiavo case years back, the Florida case where Terry was alive, but she didn't have any machines keeping her alive. The only thing keeping her alive was artificially administered nutrition and hydration. And there was a debate between her parents and her husband as to whether Terry would want to be taken off of life support. Had she signed a living will during her lifetime, then there would have been some direction for the court. I'm not saying the living will would have avoided the fight. There probably still would have been a fight, but at least the court would have had some direction. What were Terry's wishes?
We probably wouldn't know her name. It wouldn't have been that big of a public deal, had she had a document that gave some direction.
Yeah, it would have given the court guidance, and her parents and her husband, for that matter, guidance as to what she would want in that situation. So you'll be preparing these documents for your clients when you meet with them on a wills day. These directives, when the first responder leaves, and this is more for your information, you don't necessarily have to talk to the first responder about it. You actually, I would encourage you to, but if you forget it, it's okay. It'll be in their packet. The Arizona Secretary of State has a website you can go to, and you can load or you can register your healthcare directives online. So you fill out a form, and the form's available online. You send the Secretary of State the form with your healthcare power of attorney and your living will. They will scan it and send you a wallet ID card so that anywhere you have internet access, you can pull copies of your healthcare directives. It's a free service and it's very easy to use. So we provide information to the first responders about registering their directives. This comes in very handy. If you get in a car accident and you're unconscious, what's the first thing the hospital's going to be looking for in your wallet? Medical information. Who are you? So you keep this directives registry card with your healthcare information, and they will immediately know who your agents are, and they can contact your agents. Not immediately, they have to log in. But
well, it's something for you guys to keep in mind also for your own personal things. If you've done your estate planning, and hopefully you've done that. If not, you should. Everybody should, not just the first responders in that, but you should be thinking about it and kind of take that to note about doing the online registry.
Yeah, the warning that I didn't give 2 slides ago about the healthcare power of attorney, if you don't have a healthcare power of attorney and you are incapacitated, the only way, absent emergency circumstances, your family and loved ones can make decisions for you is by going into court and proving that you are incapacitated to a judge. And that's a guardianship proceeding. So that's 2 different proceedings you would initiate if you're incapacitated, or your family would have to initiate if you're incapacitated and you don't have these power of attorney documents in place. So if you haven't done it for yourself, I strongly encourage you to do that.
A simple document can
Very
really
simple, yeah.
make it easier for your family. So we're going to talk a little bit just about the landscape of probate and estate taxes, because most people think, I've heard that there's a really big exemption and I don't have that much money, so I don't really need to worry about probate. Well, these are two completely distinct topics. Probate is the court process to determine where your assets go when you pass away. And estate taxes and income taxes, well, those are the inevitable things. We all pay income tax every single year. If you have an estate that's more than $5.45 million, then you'd have an estate tax issue. Based on the clientele that we work with and the restrictions that we have in the program, we have limits, so none of the clients that would be coming through to the program will have an estate tax issue. When a person passes away, their loved ones will still have to file an income tax return. You can't get out of an income tax return just by dying. But that's why this particular slide identifies probate as something completely separate from taxes. So probate will be governed based on either a will or how something is titled, and we're going to talk about that a little bit.
And your clients may sit down and say, I want to make sure that I avoid probate because I don't want the government to take my money. I've heard that so many times from people with, all across the spectrum of individual clients or clients through the program. And this is just to help you make that distinction that probate has really nothing to do with taxes. They're two separate concepts. And Denise will talk you through.
We'll walk through that a little bit, yeah. Most people have heard hubbub on what the estate tax exclusions are, the applicable exclusions. And this is a lifetime amount. We have this slide just so that you're aware of it. You don't have to commit this number to memory by any means. For 2016, the amount of a lifetime exclusion is $5.45 million. That was a number that was set at $5 million several years ago, and it's indexed for inflation, so it keeps going up. So for 2016, that's the number. Not many people are going to know that number, but we just wanted you to be aware of it. Again, the folks that we're going to be helping would not have those kinds of assets. And the reason that's important is because if somebody had what we would call a taxable estate more than that amount, there's a lot of different planning that would need to occur in order to help minimize taxes or defer them.
And this number was a moving target for years, so
Yeah.
you'll have people that will remember the $675,000 exemption. So they'll be thinking, oh my goodness, a $750,000 estate, I'm subject to tax. So you can disabuse them of that. We now have a permanent $5 million.
Yep. So let's talk a little bit about how to avoid probate. Again, like Tricia said, you'll often hear that from the clients that we're going to sit down with. Oh, I want to avoid probate. I don't want to go through it. Well, these are ways to go through probate. We're also going to show you through this training that going through probate is not the end of the world and can sometimes be extremely helpful. But the way to avoid probate, and again, this is for your knowledge too, is if you look at an asset, the registration of that asset is going to dictate who it goes to. So if you have a certain type of designation, then it's going to say it's going to go to my spouse if it's a joint title with right of survivorship. If I have a beneficiary designation. So you're going to look at the specific assets to determine look at the specific assets registration to determine where it goes. There are things called payable on death or transfer on death, POD, TOD. You might have seen that on some of your accounts. That means when you pass away, then it's automatically going to pay upon your death to somebody or transfer on your death to somebody. That doesn't go through probate because the court doesn't need to get involved on who it's going to go to because that designation says it's going to go to my husband, it's going to go to my sister, whomever. Beneficiary designations, y'all probably have life insurance, company life insurance and benefits. And when you first sign up, what do? You fill out a beneficiary designation form to say if something happens to me, this is who should receive that. So the same thing. Beneficiary designations are very important. And what some people know, some don't know, for real estate, there's something called a beneficiary deed. And that's actually a recorded document that says upon your death where you would want a piece of real property to go. So that's another way to avoid probate because that deed dictates the transfer. And then the other thing is to own assets in a trust. And that's really more of a freestanding revocable type of trust. And we're going to talk about that. We're going to talk about what we do in the Wills for Heroes program and what kind of trust we don't do so that there's some clarity there. But if you own title to an asset in a trust, the trust never dies. The trustees might die, and then somebody else steps up, but that trust entity never actually dies. So there's not an issue of where those assets go. So assets in a trust avoid probate. When looking at titles, there are a lot of different types of assets you've got to look at for that registration. So you want to make sure that things are consistent with your estate plan. And the reason we say this is because there will be those assets that go according to the designations, and then what we're preparing is an actual estate plan that has terms of where things are going to go. So you want to make sure that things are married. Now, as part of the program, we don't go through every single asset with the client and say, you should do this or you should do that. Our goal is to work on doing the will and then the power of attorney instruments. But it's important to kind of give the client some homework and say, take a look at these, make sure they're consistent. The reason I say that is because if somebody says, I want everything to go to my sister, I want to make sure she gets absolutely everything, and then they forget that they've listed their brother on designations when they first started working, well, those two things are conflicting. So making sure that they're the same is very important, or at least that they just go along with the wishes of the first responder. So look at brokerage accounts, look at bank accounts, look at real estate, and that's based on whether something is community property with right of survivorship. That's what the CP with ROS is, and then sometimes joint tenants with right of survivorship. And then vehicles, that's another thing people will often ask, like, what do I do with my car? You can have it be an or status, and then that would automatically transfer to a spouse.
And there's also, we meant to add this to the slide, the Department of Motor Vehicles now allows you to name a beneficiary on your car.
Mm-hmm.
So if you don't want someone to be a joint owner on your car, but you would like them to get the car at the time of your death, you can actually add a beneficiary directly through motor vehicles.
Again, we briefly talked about this. Payable on death is an account designation that determines where assets are going to go upon your passing. You don't have probate, again, because there's no question as to where those assets go. Whenever you're setting up an account, this is something that you can be asking your provider whether they have payable on death or transfer on death. And again, it trumps any estate plan documents because the wills that we're going to prepare only govern assets where there's a question as to where it goes. So if I have an asset in my own name, if I've got a bank account in just my name, and I pass away, and I don't have it payable on death, court would say, well, where should it go? Then they look to my documents that I've prepared and say, oh, okay, she wanted her assets to go to, to this child, to her sister, to her husband, or whatever. It's really easy. You can go ahead and advance to the next slide. It's really easy to set up payable on death accounts. You just do that when you're setting up the account. So super, super easy. We say they transfer assets as is. Here's why. If I said I wanted $200,000 to go to my sister, and so I named her on an account, and then later I just had an awesome spending spree, and I pulled a lot of money out of that account, and when I died, there's $5,000 in it. That's what she's getting. She's getting $5,000. She's not getting the $200,000 that I was planning. So whatever the amount is in the account is what she would get. If I named Trisha and I then spent it down, she would be very upset with me. But it's whatever is in that particular account. You can usually add contingent beneficiaries so you can have a backup. So that's a nice planning opportunity. And again, as we said, it avoids probate. There are a couple disadvantages. Again, only the assets in that specific account are actually transferred. It's not a document that governs other assets or even similarly situated assets. Each asset has its own designation. And it doesn't address incapacity. So if I have a bank account, it's just in my name, and I no longer can act for myself. If I don't have somebody else that's on there, then we're going to have to look to the other documents, the power of attorney instruments, to use it. And to get in there, and it doesn't address estate tax issues. Again, sort of beyond the scope of the planning for our program, but we wanted to point that out. Again, beneficiary designations are going to trump anything that's in an estate plan. Those are going to be the entity will look at itself, would look at those documents first, and they do avoid probate. So here's things for your own consideration. Here's some assets to consider: 401ks, IRAs, life insurance, annuities, bank accounts. For our clients, they'll talk about 457 accounts because that's what they have, and we'll go into that and give you a little description of that when we're doing our interview today, so that you have a better understanding of
What does Donald Trump's estate plan have to do?
Yeah, so that we should actually, it says Trump estate plan, we should actually change that. This is not some endorsement, trust me. So yeah, we need to figure out a different word for that. Yeah, we are neutral. This is not an endorsement by any means. All right. When you're doing a beneficiary designation, some things to think about. You cannot name minors as beneficiaries. Minors, as you know, are considered incapacitated under the law, so you can't be naming minors as beneficiaries. Again, we've said this, and some of this will feel repetitive, but we're just trying to get certain points across. Making sure that the estate plan is consistent with the beneficiary designations is key, and that's also why you got to look at them periodically. We talk about estate planning. We don't call it estate done for a reason. Never done. Never done. There's always things that change in a person's circumstances. We often say every couple of years. For the first responders that come through the program, if they want to make a change in their plan, they don't call us and say, "Oh, I just want to, change this one little part." They actually come back through the program the next time that their department is having an event, or they'll be able to coordinate and come through the program with another department. So we definitely advise if something changes in your circumstances. That could be getting married, that could be getting divorced, that could be having children. Those are times to think about coming back through the program. And so looking at all the other documents, the beneficiary designations that people have. So there are certain advantages of naming your spouse for specific assets like IRAs, 401ks, and that. So that's going to give some deferral opportunities. So if somebody asks you a question and you're not comfortable answering that, again, raise your hand. There's always going to be somebody who can come over and answer those questions for folks.
And a lot of this, or most of that, is for your benefit. You won't be counseling clients on titling, on beneficiary designations, on any of these things. It's mostly, again, for you. So you have an understanding that the will does not mean the plan is done, that you need to tell your clients, go out and look at these other things, and you can highlight what they are, but you don't have to tell them what they need to do on the designation. So, in fact, we do not want you giving them advice on that information. Okay, so now let's get into a will. Think back to your trust and estates class or your bar exam.
And don't shudder.
So a will, this is the document under which you name or you tell the court who your beneficiaries are. If you don't have a will, Arizona has a plan for you. It's called intestate succession, and it may or may not reflect what you would have chosen. So it's important to make an informed choice. If you don't like the statutory scheme for intestate succession, then the will is the route to go. The advantages of the will is it's fairly easy to establish. There's a nice statutory scheme that tells us exactly how to create a will. The will is where, if you have minor children or children with special needs, this is where you nominate a guardian for those children. This is where you also name the person who will take control of your assets when you die. So someone who can make sure your last income tax return is filed and paid, and all of your last illness, funeral expenses, all of those things are taken care of by your personal representative. And again, the Arizona statutes have a scheme that says who your personal representative or which of your family members have priority to be personal representative, and you may not think that your brother's the best choice, for example, to be your personal representative. As Denise mentioned, the will only controls assets that go through probate. So think about all the titling discussion we just had. If you haven't done any of those things, you're the only person named on an account, you left a blank on an insurance contract who the beneficiary should be, or your beneficiary on an IRA died before you did and you never updated it, you may have assets that need to go through probate. Your will controls what happens to those assets, and there are advantages to probate. Denise alluded to these. Arizona, the probate process is not as onerous as it might be in other states. It is pretty straightforward. There's a self-service website, the Maricopa County Superior Court posts, that has great step-by-step instructions on how to take an estate through probate. One of the advantages of doing that is that you close the creditor period in 4 months. Once you file a probate and you publish notice and you send notice to known creditors, they only have 4 months to file a claim against the estate, and if they don't do that within that window, they're forever barred from coming back against the beneficiaries of that estate. So that's a nice benefit, especially if you've ever been asked to be a personal representative and you have no idea what Aunt May's creditors might look like. You can publish and just wait that 4 months and then be confident you can make distributions without being responsible for those claims from creditors. Some of the disadvantages, I just talked all about how great probate is, but the
There's always
disadvantage,
pros and cons.
there's always
right?
pros and cons. On the flip side, probate is public. So anyone who wants to go in and pull a copy of a will of someone who's filed a probate in Arizona can do that. You can pull the case file and look at all of the information that's been filed in that proceeding. So it is public, and it only transfers probate assets. So there's a false sense of security. I go through Wills for Heroes as a first responder. I sit through that hour appointment. I leave with my will in hand, and I think I'm done. And if my attorney hasn't counseled me, or if I didn't listen to my attorney counseling me, I may think I'm done. But my will controls nothing because I left my brother on my life insurance and my sister on my 457, and I have a joint account with ex-girlfriend two times ago. So my assets may be going places I don't intend, and I think that my will cleans it up, and it doesn't. The will does not address incapacity, similar to the payable on death and the beneficiary designations. Without the healthcare power of attorney and the financial power of attorney, no one can take action for me simply because I have a will. So my personal representative can only control assets if I die. The probate process, it may be time consuming, and as I said, it's public. It can be costly if you have people fighting, especially. It is costly.
Well, it's interesting, whenever somebody famous passes away, the media is out there. This is what was in their estate plan, or we couldn't find out anything because it was a will that transferred to a trust, and they make a trust sound like this, horrible secret thing. It's a fabulous secret thing, because otherwise the media would be in there poking around for what's going on. So, but just the fact that something is filed in probate, that piece of it is public.
Denise just mentioned a trust. So I'm going to cover revocable living trusts just at a very high level. We do not draft these for first responders, but you will be asked, I guarantee it. What's the difference between this will you're drafting for me and a trust? I heard about a trust on the news. Should I have a trust? You can do this and ask the site coordinator to come over and answer that question if you don't feel comfortable. But I want you to understand, what is a revocable living trust? This is a document. There are three parties to the document. It's a contract between the grantor, the trustee, and the beneficiary. Right? It's really a contract. If you're setting up a revocable living trust for yourself, it's a contract with yourself. How do I want my assets to pass when I die? Who can control my assets when I'm incapacitated? So when you set up the trust, you are the grantor, the settlor. You're establishing it. You're funding it. You are the trustee. You're the person who controls the beneficial interest in the trust, makes decisions about how should things be invested, how should things be distributed. You are also the trustee, and you are also the beneficiary if it's a trust, revocable living trust during your lifetime. The meat of the will, all of the things we've been talking about, who gets my property, when do they get it, how do they get it, we take it out of the will and we put it in the trust. All of those terms now are contained within that trust contract, really. The will simply says anything that goes through probate, I want it poured into my trust. So you then get a pour over will. We do not draft these documents. We do draft a testamentary trust. So in a will, we have, if a beneficiary is a minor, so anyone under 18 cannot inherit property, that would trigger a conservatorship process, and we don't want to do that. So within the Wills for Heroes, we have a very skinny, simple, straightforward trust that holds back to either age 18 or 21. And we pick those ages specifically so that our personal representative could open an UGMA or an UTMA, a Uniform Gift to Minors account or a Uniform Transfer to Minors account on behalf of that beneficiary. It's a very easy way to hold back money until someone's of age. So you will see a testamentary trust, some trust language, which can be confusing, but that's much different than the revocable trust I'm talking about here. So unlike a will, your trust does provide incapacity protection. So you are the trustee during your lifetime. You name successor trustees, and those trustees can step in if you're incapacitated, and they will step in at your death. So there is some protection there, unlike the will, where you have to wait until you die before your personal representative can do anything. Your trustee can step in. And in our experience, I'll speak for Denise, because we've had these challenges together in practice, the financial power of attorney is fantastic, right? It is statutory, you follow the rules, every state has its own scheme. The problem is that every institution around the country is looking for a different form, and they have their own financial power of attorney forms that they want to see. So they may reject a perfectly valid Arizona financial power of attorney when you submit it to take control of a bank account. they are much less likely to do that if you are a successor trustee. For some reason, they're much more, that's more of a national standard, if you will. So in terms of, for your own estate planning, look at a revocable living trust. It provides much more protection if you're incapacitated than relying on the financial power of attorney.
But it also takes a lot longer to prepare one. I mean, that's really one of the reasons that in the Wills for Heroes program we can't do a freestanding revocable living trust. That takes typically a series of appointments with an attorney. It takes a lot of time to actually be drafting that. You're able to put in a lot more provisions about when you want somebody to receive assets. So it's a much more time-consuming process to get it created. And you'll probably be asked that question. Well, like Tricia said, should I have one of these? Should I not? Am I getting one of those today at the appointment? So again, this gives you the overview of how you can explain it. But if you forget, just raise your hand and we'll come and help you with that. Yeah.
So, Jed, when we do get asked that question, what's the difference between a revocable living will or a revocable living trust and a will? Is the short answer that a revocable living trust is funded now and a will is funded at death? Is that the short answer?
That's the short answer. And then as you get into more detail, so a trust provides more flexibility, much more flexibility outside of the probate context. So I'll use myself as an example and how a trust can be used for me. We won't get into that. There's some tax planning that can be done in a trust for married couples. We won't get into that today. Like, if you have any questions about that, we're happy to talk to you about it. So I'm in a second marriage. My husband is not my first husband, and my two older children are from my first marriage, and I have a son with my current husband. So if I'm the first to die, I don't want to leave everything to my husband. I want him to be able to use the property during his lifetime. But when he dies, I want to make sure my 3 kids inherit what's left, not just my 1 child with him. If I leave everything outright to him, what could happen is once I'm gone, I'm the catalyst, I'm younger than him. Excuse me, he's younger than me. So if I die first, then the catalyst to that relationship between him and my daughters goes away, and he could live another 20, 30 years. What happens to the money if I just give it to him? So if I have a trust, I can set up a mechanism under which he gets the benefit of my money that I leave during his lifetime, and at his death it goes again to my 3 kids and not just his 1. That's just one example of how a revocable living trust provides much more flexibility than we call these I love you wills that we're preparing for these spouses. It's, I love you, everything's going to you. So I'm relying on you to do the right thing when you die and make sure it gets to the people I wanted it to get to once we're both gone. But that control is gone. If you just rely on a will, you've lost the hand from the grave control over what happens. I also have 2 grandchildren who are very young. So if I leave money to them through a will, we already talked about the testamentary trust that would hold back till they're 18 or 21, but maybe I don't want it to be held back just until they're 18. Maybe I want the money to be held back until they're 35. 45. Maybe I want it in trust for the rest of their lifetime to provide some asset protection for my grandchildren. I can do that through a revocable living trust. I can't do that as easily without court involvement through a will. You like my little caveats? As easily without court involvement. There are ways to do it through a will, but it's a little more cumbersome.
With a trust, do you completely avoid probate? I guess my question is, does something get filed in probate court or absolutely nothing? Like the courts don't know that you died?
So if you, in Arizona, so each state is different, but in Arizona there is no requirement to file a will. You don't have to probate anything. So if I do my job, I create a revocable living trust and I fund it during my lifetime, meaning my accounts are not Tricia Baggs, they're in the name of the Tricia Baggs Trust. My house is in the Tricia Baggs Trust, and everything that I want controlled by that trust is owned by it. Then there won't be a probate when I die. Now, my trustee or my personal representative may say, well, Tricia was living kind of on the edge, so we want to file a probate just to get that creditor period running. Maybe they do that. Or now under the Arizona Trust Code, not to complicate things, I can publish notice under a trust now too to get that creditor period rolling. So the short answer is, if you do it right, no probate.
And regardless of the amount that's in it, I mean, you could have a $20 million trust, and you don't have to file a probate if there's no assets to go through. Or you could have a small estate that goes through probate. I mean, it all depends.
Yeah, and that's not to say that the idea of a trust is not to keep the secret from the ultimate beneficiaries of the trust. So if you are a beneficiary of a trust, you are legally entitled to notice. So that successor trustee will have to give notice. So it's not like once I die, my kids will have no idea what happens to the money when Sean dies. They'll get notice, but not through the probate process, through a private direct notice approach. Does anyone else have any questions about a revocable living trust? It's just a much more of a planned management approach to distributing your assets rather than just an outright, I love you, here's your money, through the probate process.
We're going to talk a little bit about gifting, which is a slightly different topic, but it could also come up during your interviews with the clients, with the first responders. So each person, we talked a moment ago about taxes. There's income taxes that everybody pays every year. There's estate taxes that you pay if you have over a certain amount. And there's also gift tax that you could possibly pay if you gave gifts over a certain amount. But there are some exceptions. If you give $14,000 or less to any individual every single year, you do not end up paying any gift tax. So if you have $14,000 that you'd like to give to me, I can help you to facilitate that, and you won't be paying any gift tax. People kind of get the concepts mixed up, but that's something that can be given. Clients can also pay for tuition. They can set up a 529 plan, and some people might ask about these 529 plans when you're counseling them. This is an educational account that you put money into, and it grows over time tax-free, and if the money is pulled out by the beneficiary or the owner for qualified education expenses, higher education expenses, then it comes out without any taxes being paid, no penalties. And it's a pretty awesome thing. Again, I kind of plant that seed for you all if you have kids or grandkids or other folks that you help to support with a college education. They're pretty great plans. 529 is the Internal Revenue Code. That's why they're called 529 plans.
And pop back to that $14,000 a year. If you give more than $14,000, you may not be triggering an estate tax. You have to report that gift. So if I give $114,000 to Denise, I have to report. You're welcome. I have to report the gift, and that $100,000 reduces my lifetime exemption at $5.45 million by $100,000. So think of the gift tax return as the way the IRS keeps track of what you've given away beyond your $14,000
and just whittles away your lifetime exemption. But somebody's not actually writing a check until they've fully given away $5.45 million. Yeah, good point. Thank you. There are other options that people can give money away or pay for things without incurring a gift tax. A lot of the clients that I work with in my personal job are wealthy, and they look at paying medical expenses for their family members, and that's totally fine. They can do that. They could pay medical bills, that are in the hundreds of thousands of dollars range, and I've seen those bills come through. And they're not paying any gift tax if they pay directly to the medical institution, if they're paying directly to the hospital. They don't give the money to the person and then have them pay it, but they get the bill and then they facilitate getting that bill paid. So that's another way, and again, something for you all to think about if you're in a position to be helping folks that way. And then charitable assets. Certainly people can be giving, or charitable gifts, people can give away assets to charities, and as part of our process, we usually will talk to them in my current position. If people ask about charities and things like that in your client meetings with first responders, if they're giving assets away, that's wonderful. There are certain assets that are better than others, things like IRAs, because of the income tax consequences of passing that on to somebody else. If you give it to a charity, the charity doesn't pay any income tax when they receive it. If an asset like an IRA was given to an individual, when the person would pull money out, then they would end up being taxed on that. So certain things are better gifts than others. I don't know that I've had a lot of first responders ask about things like that. Oftentimes they're more interested in what Wills for Heroes is. This is a free thing we do. We don't expect them to donate. We don't expect them to give us one single penny. They are giving us a benefit that is priceless with what they do for us as first responders. But sometimes people will ask about Wills for Heroes, and Wills for Heroes is a 501c3 charity. People can actually make gifts to that. Some attorneys, that after they leave, they volunteer. They think, wow, I don't just want to give my time. I also want to give, I want to give a check. So we are a 501c3. That's kind of the only way that comes up. We try to remind people that estate planning is not a do-it-yourself project. You all have your own practice areas. I suspect there's no way in the world I could ever dabble in your practice area without having a huge malpractice claim. So we do just try to remind the attorneys that are volunteering. It's not a do-it-yourself project. We're here to support you when you're, counseling the clients. And for your own personal estate planning, please just don't go to Office Max or Staples. No offense, no, I'm not trying to mess them up, but get a colleague of yours or somebody else at a different firm to do your actual estate planning. Don't think that just based on the information that you've got right now that you can go, and grab some form and fill it out. Not a good idea. Here's why: you get one chance to get it right, and when you figure out whether you got it right, when you're dead. And so there's not a lot of do-overs. So that's why we put that little. It's not a do-it-yourself project.
And there are a lot of taxes. We've talked about estate taxes and income taxes. There's also a generation skipping transfer tax. There's an interplay of state and federal law that comes into play when you're putting together a revocable living trust.
Try to remind folks that there's a team that should be involved when you're doing your own estate planning. Obviously, you're the client. You're also an attorney, but you would want to consult with an estate planning attorney. Whoever is your financial advisor, whoever handles your life insurance, your CPA. Bringing that whole team together when you're planning is going to give you the most robust plan that you can have. At Wills for Heroes Days, first responders aren't bringing in their CPA. They're not bringing their insurance guy. They're not bringing their investment person. But that's why we just remind them, hey, you've got an estate plan now. When you go meet with your CPA, let them know you've done this. If you're meeting with your financial advisor, put it on your agenda as your topic to look through your beneficiary designations and take in your estate plan to make sure that things meld.
Now let's talk about, we've given you an overview. Does anyone have any questions? Are there any pieces of that puzzle that don't feel like they fit? Something that you're still having a question about on basic estate planning concepts?
I do have one question. If you have a first responder that has a child and not a spouse, it's a minor, you said you can't really give beneficiary for it to a minor. How do you attend to that?
So when you get asked that question, I'll answer the question to you directly. So if I'm relying on a will to take care of that child and I have that hold back to 1821 under a will, I have to push all of my assets through the probate in order to get it into that what's called a testamentary trust. In private practice, if that's a client coming to me, I will say, you want a standalone revocable trust. We can avoid probate. We can take care of that minor child until we have more flexibility on the ages. So in this program, in order to get those assets in the trust, they have to go through probate. That's the only way. And you will get the do-it-yourselfers that say, I'm just going to leave everything to my mom. She'll take care of my child and give the money to him or her when they're of age. And that rarely works out because the right thing today is never the right thing in that person's mind when the child becomes of age.
But through the program, setting up a testamentary trust is the way for a first responder to give their assets to a minor child, hold them back until that child is 18 or 21. And then the person who's looking over the purse strings is the personal representative that they've designated. That person also serves as a trustee that's going to watch over those assets until the child's of particular age. And there's interplay. Again, we're also talking about guardians, and we'll go into that a little bit more when we're doing the interview so you can see how that plays out. But, whoever the person names as the guardian is the one that is taking care of the child. And then they look to the personal representative to help pay for the child's expenses. So sometimes that's the same person. Sometimes somebody will have the guardian be the same person as the personal representative. And sometimes they're different people. And so those can be some client counseling points also. If they're naming two people that hate each other, and now they're forcing them to work together for the sake of their child, they might want to rethink whether that actually makes sense. For some of them, they might go, yeah, I'm going to totally force them to do that because then I know that the best interest of my child will be protected because they're going to kind of nitpick each other to make sure that what iron sharpens iron, I guess. But those are things to be considering when counseling. Does that answer your question? How to get it to?
So what documents we do prepare, we prepare that basic will that includes the testamentary trust for minor beneficiaries. And a minor beneficiary, maybe we'll interrupt during the drafting, but a minor beneficiary could be a child, it could be a grandchild. You have to think beyond, when you're putting these wills together, your clients need to think beyond the immediate beneficiary. So your spouse may not survive you, Unfortunately, sometimes your child doesn't survive you. So then who's that next beneficiary? So you may want to put holdback language just in case you have a minor beneficiary. The clients get a financial power of attorney, they get the healthcare power of attorney, and they get the living will. So those are the documents you will be drafting, and we'll walk you through the drafting system. So what we don't do, we will not meet with clients who have assets in excess of $750,000. So when you look at the questionnaire, when a client sits down in front of you, they'll give you the questionnaire. One of the first pages, we've asked them to give just a rough sketch of their assets. If that number exceeds $750,000, raise your hand. We'll have a site coordinator come over. That person will be disqualified from the program, and we'll refer them to someone who can put together an estate plan at a discount for them.
There are some times if the person's disqualified, sometimes we can still do power of attorney instruments, and we will do those. But because of the tax planning and other nuances for doing their will and trust, that's when we'll refer them out. But again, you don't have to be the ones to deliver that message. We'll just raise your hand. We'll come over, and we've done it before, and we explain the why. And I think when clients understand why, they're fine with it. But they still can go out the door, at least with healthcare power of attorney instruments and general power of attorney.
The same thing applies if your client has an interest in a farm, an interest in a family business.
Mm-hmm.
Those are issues, obviously we can't address that in an hour, nor can we adequately plan for someone who's got those types of interests with a straightforward will, the simple will we have in the program. If the client has a child with special needs, we cannot do drafting for that child. That's an entire subsection or subset of specialty in the trust and estates world. It's very easy to disqualify someone who is taking advantage of benefits from getting those benefits, even if the amount of money going to them is very small. So that's a special area. We refer that out. If the spouses are, either one is not a U.S. citizen, we can't do drafting for that person either. There are special tax rules that apply to non-citizen spouses. So again, we refer those things out. So you might want to add that on your list, the non-U.S. citizen. If you see someone is not a citizen or the spouse is not a citizen, raise your hand and we will come over and counsel through that.
Tricia, Denise, there's also a hot topic, gun trusts. Do we do those?
We do not do gun trusts. So there are certain weapons that are regulated by the federal government. They have to be registered in a specific way, and you can't pass those weapons, or you need to follow specific guidelines to pass those weapons on to beneficiaries and heirs. And a lot of folks use something called a gun trust to accomplish that. We do not draft gun trusts, nor can we counsel on how people can set those up. So we can refer them out. Okay, so our documents, again, back, not to beat this thing to death, but we tend to. The will does not avoid probate. In fact, in order to effectuate the client's wishes under the will, we need to go through probate. If you think back, what does the will control? It only controls probate assets. We don't advise clients about how to title their assets, either get them in probate or to avoid probate. And we don't provide the flexibility that the client could take advantage of through a revocable living trust. Our wills are very straightforward by design. They are very limited in how, we don't want you going out there and custom drafting a special pet trust or holdbacks to ages when you get a car and you get distribution when you get married to buy a house. We're not doing things like that. It's very straightforward. Income and principal for health, education, maintenance, and support, and then outright at 18 or outright at 21. They're very straightforward. So that you lose a lot of flexibility by coming to the program, but what you get in return is a very basic estate plan, and we keep all of us as attorneys who don't practice in trust and estates, it keeps you out of hot water. So you're not venturing into areas where you could trip up.
Don't go rogue.
Don't go rogue.
Stay
with the document.
Stay within the document, folks.
Does anyone have any questions about the limitations of the program? Or
I have a question.
Yeah.
Just how do you arrive at the $750,000 cap if the estate tax is like $5 million, $5.4 million threshold?
We initially picked that number when the estate tax exemption was dropping to $1 million. Okay. So that's where we came in with the $750,000. And we stuck with that number because we think that's reasonable. Someone who has more than that really should be doing something with more flexibility than what we can offer through the program. And they can go out and get a private attorney for that. And again, we have attorneys. When I was in practice, I would give a discount to first responders who came through the program so that they could avail themselves of legal services outside the program.
Good question.
Very good question.
It sounds like we've talked about what we don't do, but there's a lot that we do. And they really appreciate getting a structure for an estate plan and having some comfort that the people that they name as the guardians are going to be the guardians for their kids, that they've actually thought about the process. They don't think about mortality. Otherwise, they wouldn't go into burning buildings. They wouldn't do things like that. But this is a Saturday that they're taking, with their spouse to actually think these things through. So that's another reason why we try to keep it to an hour, make it a program that's easy. Like the one gentleman said on the video, he's 52, didn't have an estate plan because he doesn't want to think about it. And he wouldn't have done it but for the fact that it was an hour and it was free and it was an easy process. The folks that helped to coordinate the different sites that we're going to go and help the first responders are very supportive of their departments, and they want to bring people into this so that way they know that those folks are protected. On the video you saw, and we'll talk a little bit in just a moment. We're going to take a break here, and then we'll talk about what the room looks like, what the actual day feels like, and get into the nuts and bolts of actually how to create an estate plan. But it's an amazing program. So even though we talk about what we don't do, there's a lot that we do.
And that's one of the reasons we take the program to the departments, and we don't say we're going to host this at the state bar facility or at a law firm facility. We go to them to make this as easy as possible, because as Denise pointed out and as the video points out, otherwise it wouldn't get done. And one of the impetus of the program, Jeff can speak more clearly to this, was of the first responders 9/11. I don't know that any of them had an estate plan that were killed on 9/11, and that was kind of the impetus of this program, was how do we help people, how do we make it easy, how do we bring it to them and get some basic plan in place.
So is everyone ready? We're back. I want to highlight a couple of things before we dive right into the interview itself. Wills for Heroes was really started by an attorney, Anthony Hayes, out of Columbia, South Carolina. Anthony worked in the towers, grew up in New Jersey like I did. I grew up in New York. I worked in the towers growing up. But what was different about Anthony and I is that when the towers went down, Anthony, instead of getting into his car and heading to ground zero, which he was really contemplating, literally drove to a firehouse in Columbia, South Carolina and said, "How can I help?" And they looked at him like he was crazy, the lawyer wanting to help. That's those two things don't jive, right? And they just sat around. The guys that were on the shift sat around. It basically turned out to be a little focus group, and they were chatting, and it turned out that none of them had wills. And he said, "Wait, hold on. You guys run into burning buildings for a living? None of you had wills?" And that's really how the Wills for Heroes program was born. He started it in South Carolina. It expanded to Virginia very loosely. I met Anthony through our respective involvement in the American Bar Association Young Lawyers Division. At the time, I was rising through the ranks of the State Bar of Arizona Young Lawyers, and we were looking for a new pro bono project. And I said to Anthony, let us incubate it in Arizona. We will put together sort of a format as to how we want the program to go, because we started getting calls from other states wanting to do the program. And we put it before the State Bar of Arizona. We put it before the State Bar General Counsel. And for 9 months, we focused the program, made sure that we had set it up structurally so that other states could replicate it. Got the State Bar Board of Governors to approve it, had our General Counsel review all the documents that we were preparing, and in June 2015 did our first event here in June 2005.
Right.
Thank you. June 2005.
Doing this a whole lot longer than that.
June 2005 did our first event with Oro Valley Police Department. We had 3 computers and a printer on a rolling cart that we literally rolled and connected to each printer. And the program has significantly evolved since then. We've done over 8,800 wills in Arizona alone, more than 60,000 nationwide. The program is now in 28 states, and we created a foundation around it, as Denise and Tricia mentioned earlier. It is a 501c3, and folks like the program in Pennsylvania, the program in Wisconsin, the program in Minnesota have really taken this them to the next level. So we're incredibly thankful to all of you and all of you who are volunteering, because we could not do this program without you. The demand, even after 11 years of this program, is still incredibly high. There is still a significant wait list of departments that want to do the program. And we try to do as many events as we can by not burning out our volunteers.
We were talking on break about when we first started, it was like every Saturday we were having an event from 8 to 5, 8 to 5, 8 to 5. And it was just that joy of helping people that kept us going. Eventually our families were like, hey, remember us? And we're like, oh, yeah, we do love you. But this is something that we were very passionate about. And so as the program has grown, we've had to put more structure around, how many events we can actually do, when we can do them, and that. But it's, Lori was mentioning she's volunteered several times and has felt that joy, and I think you'll all feel the same.
So I wanted to highlight a couple things for you. In your packet, right after the sample interview, and it's on the screen here, is the Attorney Code of Conduct. One of the reasons why we developed a foundation and we made a template really for the program is to maintain the ethos of the program. And that is that it is always free. No first responder will ever be or feel like they were solicited for business. It's not to denigrate personal injury lawyers, but no personal injury lawyer is going to hand them your card, hand them the card and say, hey, if you see a really good one, hand out my card. Those things have happened, by the way, and we want to prevent that from happening. So we developed an Attorney Code of Conduct. Another part of the ethos of the program is that this program really is about the first responders. It's not about us as the lawyers. And so we want to make sure that the program focus stays on them. The collateral benefit, obviously, is that first responders, especially police officers, see lawyers in a different light. Police officers think lawyer, they think criminal defense attorney reflexively. That's not who we are. As lawyers, we are more than that. And this has really had the collateral effect of raising the profile of lawyers within the first responder community, although that was never a goal of the program and still does not remain a goal of the program. So I'll task you with just reviewing that code of conduct at a later date. And in fact, when you sign up through the website to volunteer, and we'll talk about that in a little bit, you are required to review the Attorney Code of Conduct and acknowledge that you've read it. The attorney guidelines, which is the next page in your packet, those also will help you really go through what the program is and what our expectations are of you. The Wills for Heroes Foundation, according to the IRS, does not provide direct legal services. We do not have a malpractice insurance policy. Here in Arizona, if you do not have malpractice insurance or you are a government attorney, the State Bar of Arizona has an insured lawyers policy, which does cover Wills for Heroes volunteers. So that's only if you don't have a policy yourself or if you're a government attorney. If you do have a policy, the State Bar's employed lawyer policy is secondary to your primary malpractice carrier. So before you begin drafting, you're going to confirm that the that the first responder or their spouse or partner has filled out a disclaimer. We're going to cover that in a little bit. Review the questionnaire with the first responder. Make sure that they are at or below the $750,000 limit in their assets. And if they are above it, call a site coordinator. Just raise your hand. You'll see us buzzing around in the middle of the room talking to people. Explain what you're doing and how the program works. You want to make them feel comfortable. At the end of the day, they're there, but a lot of them don't really know what it is they're doing or why they're there. They just know it's important. It's a free service, and we've made it as easy as possible for them to participate. Stay within the scope of the program. I know that Denise and Tricia mentioned this several times, but we also want to reinforce the fact that you are, there is a reason why the template exists the way it does, the questionnaire exists the way it does. We've had our trust and estates lawyers review this over and over again. We just went through a template revision. Stay within the template. And if there needs to be some more exotic drafting, or there's something that a first responder really wants that's outside the scope of what's in the template, ask for a site coordinator and we will help you. Sometimes we can provide that, sometimes we cannot. Just depends on the circumstances. Save your documents. Save in the template, and we'll talk about how to do that. These are brand new computers, so there should not be an issue with them, but you never know. So we want to make sure that we're saving it at the end of the event. We wipe everything clean, so there shouldn't be any other documents on there. We don't save any of the electronic versions of it. So once they leave, and we don't have anything.
That's why they can't just call and say, I want to make some little change in my document, because we don't have them anymore. They leave with the only original, and we let them know that that's the only original. We don't electronically send them a copy or anything like that. It's once they leave, what's in their folder is what they've got.
Make sure that you review the documents after they are printed out. We'll talk about what that looks like physically in a minute, but once the documents are printed out, bring them over, sit down with the first responder, and make sure you're reviewing it with them. Make sure everything is spelled correctly. Make sure there are no obvious errors on the documents. And if you are looking at it carefully, you will know what an obvious error looks like, and we'll talk about that in a few minutes. And don't hesitate to ask for help. We're all there to help. We're there to support each other. Ask your colleagues, ask the site coordinator. This is a very family-friendly, loose environment. It's a very serious topic, but we try to make it as light as possible for both the first responders and our volunteers. Let's see. Yeah.
So you sign up, obviously, in advance to say that you're interested in volunteering. So you go to the website, you'll end up creating your own password and log in. And there's a page in there on how to volunteer. So that's important to do that. What to wear, we dress the way we did because this is the way we dress, although Tricia doesn't wear heels at the thing, but she's got a meeting afterwards. So jeans, comfortable shirts, no ties, no jackets, no heels. You're there to be comfortable. I would ask you don't, show up all tattered or anything like that, but be comfortable. Sometimes bring a jacket if you get cold in a room. Again, these are larger rooms, so sometimes bring a jacket. I almost always do. So just know that. It's a very collegial environment. It's fun to be in. Like you saw in the video, there's kids that are there. There's lots of conversation. Sometimes folks that are in the same unit, they don't get to see each other very often. I'm like, hey, there you are. And the wives are there, or the partners are there. And, it's a social thing also, which is really fun. Go ahead.
So the first thing that, I'm sorry, go ahead if you want.
I was just going to go on through a couple of other things with room setup and things like that.
Go ahead.
The room will typically be set up with separate tables. They might be this size, they might be bigger. And so what happens is you'll have your tablet, and then you'll sit down, and the first responder will be on the other side of the table. There's a bunch of those tables around the room. There's one printer that's usually in the middle or off to the side of the room. You come and you get familiar with your circumstances. If you want a cup of coffee, you can have your coffee on the table. Again, it's just very comfortable. The clients, when they come in, they're going to check in at the front desk. They're going to ask them to make sure that they sign a disclaimer. Oftentimes, there's the disclaimer that's on the screen. They'll talk to them about that husbands and wives or partners will actually be with separate attorneys. It's one first responder to one attorney. Or sometimes there's a couple of attorneys on one side of the table if people are shadowing. And sometimes that's off-putting because husbands and wives might come in and think, well, why can't I sit next to my spouse? Are you trying to have them do something that I don't know about? And we just explain it's separate representation. We're not trying to create joint representation. You are not precluded from going over and talking to your husband with the attorney that he's meeting with. And once they understand that, then they feel a lot more comfortable. But it is separate interviews that they're doing.
If you've ever had to go through the conflict waiver process of doing a dual rep, you know why we don't do that. Right? We have each client have their own lawyer, so we don't run into any kind of conflict issue.
Yeah.
And it has happened in the past where a first responder has leaned into me personally and said, I'm really glad that you did this separately because my spouse doesn't know about X. or Y, or the offspring of X and Y. So we do that for a reason. It's very rare, but it has happened.
There will be a site coordinator. You'll know who that person is when you check in. The flow of the day is you'll either sign up for all day, or you'll sign up for the morning, or you'll sign up for the afternoon. If you've not drafted before, typically it's helpful if you watch somebody in the client counseling process first and you sort of shadow. That will give you a better idea. We're going to go through how to do it today, but just seeing it actually happen in real life is frankly a lot more fun. And you'll see how each person kind of does their client counseling a little bit differently. Again, I highlight what Jeff said. Read the documents. This is not your job to go in to be a volunteer, to crank something out on the computer and go, okay, if you have any questions, let me know. They're not going to know. They wouldn't have any idea. So the goal is to walk through the documents. In your packet, we're going to go through an example questionnaire, an example we're going to put together an estate plan, and you've got copies of the documents. So reading through them a little bit before you go might give you a little bit more comfort. You don't have to read it word for word. We've had some volunteers that have literally said they'll get it off the printer and they'll say, okay, just let me know if you have any questions, and that's not really helping the client. A lot of times what I will do is after I'll sit them down and I'll say, I'm going to be putting in the information that's on your questionnaire into this program. It's going to create a document, and then we're going to go through it together. And oftentimes after I've done that, I'll have them come sit next to me because I can't read upside down across the table. I'll have them come sit next to me and we'll look at the document together. I'll always tell them, you can read upside down. I often will tell them, make sure that I spelled your family members' names right. Make sure I've got your addresses correct. It's not going to hurt my feelings if there's a typo in there and I need to correct it. I want this to be perfect. I want this to be what you need it to be, and let's make sure that we get that right. And they're always very comfortable. And sometimes I have Saturday morning fingers, and they'll say, "Oh wait, it's Amber, and you put Alber." Oh, thank you, and I'll switch it out. Totally fine. Let's get this right. But it is about taking the time to actually review what you've produced. You would all do that in your own private practice that you've got going on with your clients. You would read, review, read, and review. So do the same thing.
Couple of notes about the disclaimer that the first responder and their spouse or partner will review. This again was reviewed by the State Bar's General Counsel and approved. It really sets forth the boundaries within which the program operates. It is a limited scope representation agreement, for lack of a better term. That means as soon as they walk out the door, they are done. Any attorney-client relationship which may have formed has ended, and they are informed of that. That's why we don't answer questions afterwards. Sometimes we'll get a phone call, say, hey, I want to make a change, or I got this wrong, or I reviewed it and I thought differently about it. You can come back to another event, but we never give advice or give them any indication that the representation has re-engaged once they have left. The disclaimer informs them about joint representation and the lack thereof in the program. They will still ask about it. The disclaimer outlines the list of things that we do not do in the program. Number one being beneficiary designations on any assets. We talk about the fact that we are relying on the information they are providing us. We are not doing any independent check on the information they are providing us. We are also informing them that we have not performed any conflict search on their name, and that if they are aware of a conflict that arises, they are to inform us immediately. So this disclaimer is a nice protection for attorneys against any claims that might or could be brought against us.
Do you get people asking questions about unrelated topics, and I assume you tell them we can't give advice, child custody or bankruptcy?
Absolutely. So it's a great question. Do we get questions about bankruptcy or custody issues? Absolutely. And we say that sorry, that's not part of the program. We can try to help you find somebody who practices in that area, so you can set up a separate appointment with them. All right.
We never pass cards out like Jeff said. That's not something that we would ever do. Even I mean, my area is estate planning. If I was in family law and somebody started bringing up these questions, that would not be the time for me to hand them a card if I did family law. It's just to really explain to them that that's beyond the scope of what our program is, and they really need to talk to a private attorney. If they say, well, I really, really like you, go talk to the site coordinator and have that person talk to them. Good question, though.
So once you're assigned a table, the first thing that you are going to see, you're going to see a desktop not unlike this. You will double click on the Hot Docs shortcut. That's the little D. Just a note about Hot Docs: this program would not run if not for Hot Docs. It is really the engine that drives Wheels for Heroes. The original owner of Hot Docs, it essentially was its own company. It was sold to Lexus. Lexus gave us the software for free. They developed the templates for us. They coded the templates. Hot Docs was then sold to Capsoft, and we still have that relationship with Capsoft. The people who design our templates and who do all the coding and everything, it's the original engine, one of the original software engineers who actually designed Hot Docs in the first place. His son is a public defender in Salt Lake City. He also does part of the coding for us. Marshall Maurice and his son Matt Maurice. Marshall is on the Wheels for Heroes Foundation Board of Directors. Just got back from an extended mission to I believe South Korea. Anyway, so you'll go to that Hot Docs little D. You'll double click on it, and will pop up should be this screen. On the left side of the Hot Docs template, you'll see three separate documents under templates. You see the last will and testament, the general durable power of attorney, and the healthcare power of attorney and living will. Those are three separate documents. They're not all stitched together, just in case, for example, you have a first responder who comes in with $1 million worth of assets. We can't do a will for them, but we might be able to do a general durable power of attorney and healthcare power of attorney and living will, depending on the site coordinator's call on that. So the first thing you're going to do is you're going to double click on last will and testament, and it will literally pop up this dialog box that says answer file. What is an answer file? Literally, it contains all the data that you input as the answers to the questions that are on the questionnaire, and that will pop up on the template. So it is a file of all of the first responders' answers that you are going to pop into the template. So you always want to start off the will with a new answer file. Just hit OK, and you're off and running. And this dialog box is designed to follow the format of the questionnaire, which is in your packet. So from here, we're going to do some role play. I will take over the role as the first responder, and Tricia will be inputting the information, and Denise will be interviewing me.
And along the way, we'll give teaching points on different things that we see. Usually the person who's inputting and the person interviewing, I mean, this is one of, Tricia and I are one and the same right here, but just to keep the process going for time purposes, this is how we're going to do it.
Does the first responder have the questionnaire in advance?
They do. They do. They get the questionnaire, and they're supposed to bring 2 copies of it. One for them. Well, if they're married or have a partner, each person should have their own questionnaire. I will tell you, there are some times that we've had people and they show up and they only have one. Oh, we didn't know we were supposed to each have one. Okay, well, we can figure that out. Then the person who knows more of the information in their head goes off without the questionnaire. The one that needs it is there. And again, they can go back and forth to talk to each other. But the departments do just make sure that folks are, filling this out ahead of time. There are some times that there's arguments that perhaps people have had before they get to us of who's going to be the guardian for their children, because somebody likes her sister and he likes his sister better, and there's, that. So we just say, these are key things. And a lot of times the folks that are at the front table will remind them, have you both brought a questionnaire? Have you talked through the guardian of your kids if you've got them? Have you talked through some of these things? So not to say that everybody will have it prepared. Sometimes people will forget information, phone numbers and things like that. So they, will say, well, look at, pull out your phone and find your sister's phone number, and let's get it in there and that. So we'll just go ahead and again, Tricia and I will just be interchangeable. So, hi, I'm Denise.
Hi, I'm Blaze Arrest.
Let me give a disclaimer right here. He came up with these ridiculous names for this role play. All right, I'm just gonna throw you under the bus.
We had fun.
No, we had so much fun, but I think it was it was kind of group thing. So when you see these ridiculous puns of names and stuff like that,
So the first responder community, you have to know something about them. You don't want to offend firefighters or police officers by being too biased towards one or the other. We treat all first responder departments the same, whether they're police, fire, paramedics, probation officers, corrections officers, their spouse or partner, and we are now doing veterans as well. So we try to play it right down the middle. We did that from the very beginning. You'll see the symbol, the Wills for Heroes symbol that's on our shirts. It doesn't look like a police badge or a fire department logo. So we're very sensitive to that. So even in the continuing education seminars, Blaze, Arrest, and you'll see more of the same. So.
Well, hi, Sue. Nice to meet you. A man named Sue. Excellent. I think there's a song about that, isn't there? There is. So let me tell you a little bit about what we're going to do. I'm going to look at your questionnaire, and then I have a program that I'm going to put the input information into that program. Sometimes, I'll look at it. Sometimes I'll just ask you to tell me your address and that, so I can get it in the program.
So are these computers connected to the internet? Because I'm really hypersensitive
They're
about
not.
like that.
No, they're not. They're not. We have a separate separate program that's on each specific tablet, and the information that we're going to print is going just to the one printer. When we're done today, we're going to erase the files, the information that you're going to have, and your new estate plan is going to be in a file folder, and you're going to take it with you, and we don't keep any record of that.
Great,
So,
that makes me feel much more comfortable. Thank you.
Good. Yeah, you bet. So first thing I'm going to do is I'm going to look at your questionnaire for the assets. We have limitations on how many assets a person can have to come through the program, so let me just take a look. So, okay, bank account 5,000. Rough numbers are completely fine here. I see that you've got some real estate, and we're looking at the equity piece of that only. You've got an IRA or 401k, $100,000.
So what about my 457? Because it has $100,000 in it. Is that included?
Yes, so any retirement plans are included in this calculation. Even though they pass by beneficiary designation, they're not typically controlled by the will. We want to know that 750, that includes retirement plans. A 457 is a deferred compensation plan. So every first responder that you'll meet with will have an opportunity to contribute to a 457. Later down the page, you'll see mention of a pension benefit. They all participate in the pension plan as well. It's a public safety
Retirement system.
Retirement.
Public safety.
Personnel retirement system. PSPRS. I should know this. My husband participates. The pension plan is by contract. The contract defines who gets the pension plan when the first responder dies. They don't have a lot of control over that. Either goes to their spouse, or to their spouse in issue, or to their issue, depending on how old they are. So the difference between the pension benefits, the reason we don't ask for, I guess we do ask for, what we're looking for on the pension plan is whether there's a lump sum pension plan outside of the public safety personnel retirement system. The PSPRS does not have a lump sum payout. What we're interested in is what cash is going to come into your estate when you die. Okay. I went around the block on that one. But do you have any questions about a 457 or the pension plan?
They'll often have speakers come and talk to them about their pensions, don't they?
Absolutely, yeah, they do. But it's confusing, especially the new.
Right. So I'm looking, you don't have a farm or a family-owned business. We asked that question again because that would be just beyond the scope of what we've got. So let's dig in.
But I do have a boat. My wife's a real estate agent, and it's called Out of Commission. Is that?
Great. Yeah. No, you put the value of your boat, and again, you're still under the value. So cute name, by the way.
Thank you.
Yeah. Good. All right. So we're gonna just start with your name. So your full legal name I see on your questionnaire is Sue Blaze Arrest. Is that how you sign documents? I see that you just have just Blaze Arrest.
Yeah. It's I don't let too many people know my name is Sue, so it's Blaze.
Okay. Very good. Very good.
Cool.
Right. They like Johnny Cash, right? So I see that your address is 123 Sesame Street, so we're going to type that in. So again, on the screen, you just see each time, you're just selecting. The information is pretty consistent. You can either look at their form, their estate planning questionnaire, or you can just ask them the question. After we've put in their address several times in each of the documents, I get to the point where I just say, okay, what was it? What was your address again? And I'm just typing it. But initially you can just be going through this. Other times I'll also let them know, I'm just going to take a quick, gander through your questionnaire. So give me a moment. I'm going to be quiet here for a little bit, and I'm just going to look through the questionnaire. At that point, I might be looking to see, children, stepchildren, do they not have any children? Kind of what the situation is, just so I can think it through in my mind before I'm having the conversation with them.
Okay.
But I always just let them know what I'm doing.
Yeah, in terms of navigating this screen, it's like most Windows. It's very intuitive. You can click between fields. I'm a keyboarder, so I tab between fields. But it's very intuitive, the program, and just input information. Sometimes you have drop-down menus. But as I'm entering information, you'll see over here, these are my questions that I have to respond to, and as I'm inputting information, I start to get these itty-bitty little blue lines. Can you see those? It shows that I've started to input information. Over here, these are grayed out, meaning I haven't input any information yet.
And this is, you'll see at the end of the interview, if you skip something that you should have completed, one of the boxes won't be filled in, and it will identify that you've got an unanswered question. So that, again, that's one of the quality control pieces. You want to talk about what you see at the bottom there?
The information you're inputting on this screen will fill in these bracketed boxes. This is the text that will appear in the document. This gives you a little preview of what you're actually.
If you go to document preview, the document preview tab right there, you can actually, yep, you had it.
I'm going to, before I do that, before I click out of this, there's a little box here with an A on it, and I can't see this very well. I have to hover to see.
That's it. You got it.
What I'm looking for? Oh, my old lady. Okay. I'll go in here and save this answer file before I start clicking around.
Whatever nomenclature you're comfortable with. Most people use the last name, but whatever you're comfortable with. Just want to tab through that all the way until you get the OK box to pop up. But that's how you save your answers throughout, so that if the computer somehow crashes on you, you can go right back into that answer file and repopulate the document.
So if I want a little preview, how have I impacted the document? Up here is a document preview tab. I can see, okay, the blue text, those are my inputs, and I have a little preview of what I have yet to input, signified by these asterisks.
When you're reviewing the document with the client, if you ever see asterisks, there's something missing. Okay, there will not be any asterisks in the document other than something is open. And that's okay. Just if you don't know how to go back and get back to that question again, just raise your hand. We'll get you back there. But don't just start typing going, oh, I think this is what it would say. Just raise your hand. We'll get you back to the answer file, get you back to the template, and make sure that it's correct.
Really, Hot Docs is a series of if-then questions. Mm-hmm. If you are a veteran and you click that, have you ever been in the military, if you say yes, Hot Docs will automatically add language that requires the personal representative to search for benefits that may be available to veterans. If you click no, that portion of provision doesn't show up. Okay, back into character.
Back into character. Okay. All right, so I see that you are currently married, have a prior marriage, and we'll talk about that. I saw that there you've got some kids, some stepkids, and we'll walk through that in just a moment. Your wife's name is?
Megan, a big arrest.
Megan, a big arrest. Okay, well, we'll go ahead and we'll input that, and she is a U.S. citizen as well.
Why does that matter?
Well, if she's not a U.S. citizen, there's some very specific things for a non-resident or a non-U.S. citizen for their estate planning, and that's just beyond the scope. There's very specific, they'd want to talk to a different attorney about how to handle that.
Okay,
so that's the reason. Mm-hmm. Have you served in the military? I see no, so I'm going to click the box no. And we just asked that because if you were a veteran, then there are certain benefits that you could get, and we would just want to highlight that for your personal representative when they're looking at your document. So
that was on the previous screen.
So I see that you have some kids, and then we asked the question about including future kids, either adopted or born, afterwards, and you said yes.
So now I'm fixed. So I mean, I didn't think it was such a big deal. I mean, I don't intend to.
Right.
I kind of thought it was a good idea, but I'd like to know whether you agree with me or not. If it's a good idea to include that.
Yeah, so it's a personal decision, but here's what we've seen with a lot of our clients that we've worked with. Just because you don't think you're going to have any more kids doesn't mean that you might not adopt a child. There are times that you just might be drawn to adopt a child later, or perhaps it's a grandchild and you then end up adopting a grandchild. I mean, you never know. What this does by saying yes to this question is it keeps the class open, and it's just going to put language in there that says any children later born or adopted by me are considered my children, even if they're not named in here. So that's why we asked the question.
For the rest of you, this doesn't broaden the class. The client actually has to do something.
They'd have to adopt, right?
Or maybe the 1% chance that you actually father a child, despite your being fixed.
Yeah.
So this avoids the Anna Nicole situation where someone forgets to include that child.
Right. And then I've seen that you want to include some stepchildren. So let's.
Well, I have some questions around that, but
okay.
I think we'll probably get to that, right?
Yeah, well, what questions do you have?
So, I'm kind of glad that we're separate because, my wife has kids from her first marriage, and, I love them and all, but one of them I don't necessarily trust, but I feel like I have to, or kind of want to provide for them. What's the pros and cons of that?
So, most estate planning occurs by bloodline or by children that you've adopted legally. You're not required to include your stepchildren, but you certainly can. And if you want to, then what that means is that they will be included as beneficiaries of your estate, even if you and your wife were to divorce, and then those children are named in your document. So that's the thing to be thinking through, is you want them to be treated just the same from a legal perspective in your will as your biological children. So
are you saying that if I provide for my stepchildren in my will, they're treated as the same as my children, but they will also inherit from their biological parents as well?
Right.
Oh, okay. So they could double. All right, I'll leave it in there for now, but thanks.
Okay.
That's good
Yeah.
information.
And again, if you ever want to change it, you can come back through the program, and then we can change it at that point.
So I shouldn't write on the will.
Don't ever write on it. No, that's a good question though. People often think, I'm just going to scratch somebody out, and that means that they're out. Right. They're not out. No, they're not out. That kind of messes the whole thing up, and you get one shot to get this right. So just keep your hands off it. Just make a call to your department and sign up, and we'll get you back through the program. And I think as you'll see, it's just an hour. If you can make another hour time commitment, then we'll get it changed.
I'm going to make this much longer with all my questions.
And you might. I get that feeling, but this is fun. And we're here to serve you, so however long you need, we'll get through it. It's fine. We asked if you wanted to disinherit any children. You said no. I'm going to pause. I'm just going to step out of the role. Not like I'm some actress, right? But okay. What's the deal with this question? Some people will say, oh, I totally want to disinherit my in-laws, or I want to disinherit, my stepchildren. Maybe they don't want to include it. Okay. Disinheriting in this situation is just related to disinheriting a child because of the language that we have in there. But there's a follow-up question if somebody says they want to disinherit the child. If this is a first responder who has adult children that maybe then also have children, so they've got grandchildren, they might have an estranged relationship with the child. They're mad at them. They don't want to, maybe the child, has some drug issues or things, whatever the case is, right? And they don't want to include them. That's fine. They can disinherit them. But the next question is, if they have children, do they want to disinherit those grandchildren also? And some will, and some will not. It all depends on the circumstances. But it's a client counseling point if you have that situation. And again, if you're not comfortable having the situation or the conversation, just raise your hand. But there are some people that they're like, well, I'm so mad at my daughter and just livid with her, and she's in jail right now, and I'm actually taking care of the grandchildren right now. So no, I totally don't want her to get anything, but yes, I want my grandchildren to get something. That's why we have the different language depending on the circumstance. Okay. You don't get it often. Most people think disinheriting is trying to keep their in-laws from getting something, or perhaps they don't want to be including their stepkids. If somebody says, I really want to disinherit my spouse, and they don't laugh after they say that, they can't do that. And again, just raise your hand and we'll deal with that. I mean, we'll sort of deal with it. Like, we can't do the whole deal with it, but we can sort of deal with it.
We also do marriage counseling through the program.
So are you or your spouse, probably not you, but would your spouse be pregnant at the time?
She is PG.
Right. Congratulations.
Thank you.
Congratulations. The reason we ask that is just to say, that there's going to be a future child that would be born to you. So I see you have two kids, Huey and Dewey. And I see their birth dates. They're biologically yours. I'm just going to go ahead and I'm going to insert this into the template. At that point, I usually kind of stop and I focus on getting their names right, because having the conversations, I can sometimes multitask, but again, I want to make sure that I'm spelling their names correctly. You'll see on this box right here on the screen, that's where you put in the child's name, you put in the child's birth date, and then it's very important how you tab through this. So Tricia, do you want to talk about how you're working through?
Actually,
Did we get that
that
fixed
bug
now?
is fixed.
Okay. Yeah. We had a glitch before where you had to tab through everything, but if that's fixed, that's great.
And I take it it's important to get the name as it appears on the child's birth certificate. So if they write down Johnny arrest, you want to clarify with them.
Yeah. Yeah. Mm-hmm. That being said, if they just wrote Johnny and the person and the first responder passes away, when it goes through probate, there can be an affidavit that's filed that says Johnny is the same as Jonathan. Yeah, and that way, that doesn't keep the kid from getting anything.
It's probably more important if there's a person with the last name Smith or Jones than there is with somebody like Dewey Arrest.
Dewey Arrest?
Dewey Arrest, yes.
We do.
Yes, we do. I don't.
They do.
They do.
Did you say it's still showing it, Tricia? No. Okay.
And it's a 4-digit birth date of birth, so you have to put all the digits. And my stepson is Louis, a big Arrest.
Okay. So again, we would just sort of fill through this. Again, always keep an eye after you've gone through one of the screens. Look at the left side of the screen and make sure that little box is completely filled. If it's showing gray, you've missed something. If it's showing blue, then it will show that it's actually a completed part. And there's no speed requirements in going through this. We set up the appointments hourly. When the clients come in, then they'll be set up with an attorney. Sometimes the appointments will go for a full hour. Sometimes they'll go for an hour and a half. Sometimes they'll be 45 minutes. Just kind of a rolling program. So whenever somebody else comes in, when you're available, after you've finished your other appointment, then you'll sit down with somebody. So don't rush through for the sake of trying to crank something out. Again, we want it to be perfect.
We also provide bedpans. They're branded bedpans, so you don't have to get up and go to the bathroom.
You are allowed to get up. You can get up and stretch the way you need to do. And then usually the site coordinator, the people that are at the front, will then ask you if your desk is open, like, are you ready, or do you need a few minutes, and you just let them know. Okay, so let's talk a little bit. I put in the information here. We've decided, you've decided and informed me that Louis is going to be included as a stepchild, so we've got that in there. Personal representative. This is the person that is going to be handling your estate when you pass away. Sometimes people call it executor, but in Arizona we call it personal representative, in case you were more curious about that. And I see that you have listed your wife Megan as your personal representative. So I'm going to go ahead. We're going to get that information in.
And as you're going through, or as I'm going through here, you'll see. Go back. If I say, if Jeff had said he wanted, or if Sue had said he wanted a co-personal representative, and I choose yes, you'll see that Now Hot Dogs opens up another dialog box where I can put in the personal representative name. So the if-then translates here as well. So if I want a successor personal representative, if I click yes, I get a space to put the name. If I click no, that goes away. So as you go through, it's what do they call that?
The if-then logic works.
Yeah, the tree just opens up each branch.
People will often ask about having a co-personal representative or a co-agent. And our perspective is that while they legally can do that, it just makes it a lot more challenging. So talking them through what it actually looks like when they're gone, if they name the spouse and then maybe he says, well, I really love my mom and I want my mom to also be a co-personal representative with my spouse, that means through the court process, through the probate process, any documents that have to be signed by both of the people. So if they're super tight and they live close by and all that, maybe not as big of a deal, but if they're on different sides of the country, then you've got a document shuffling process every single time you're signing things. So, if somebody's not naming their spouse or if they have questions on co-personal representative, you can dig a little bit deeper, have a better understanding of why they're naming different people, or perhaps suggest that the next person is a successor as opposed to a co-personal representative. And as you read through the questionnaire, we try to give those little descriptions. So then when they're filling it out, they have kind of these client counseling points right in the questionnaire in case they've thought it through. Okay, so we've listed your wife as your personal representative, and I see that you want a successor personal representative, and you said that that's going to be Jane, your mom. So we've got her information.
Now, she's really old.
Okay.
So if, can we add somebody else in just in case, mom doesn't make it too much longer?
Well, is she really the person that you think should be handling this, or in that situation, would you actually want to name somebody else? Do you think she's capable of taking this? I mean, this is a big job. Most people think this is an honor, and while it's an honor, this means this is the person who's going to have to figure out what all of your assets are, go through all of your finances, make sure that everything is going to where you want it to go to. Is she the person that can handle that at this point in her life?
So I grew up on a guilt trip, so
Okay.
I'm pretty sure that if I didn't name her, it would I would be disowned. So
Okay.
I'm going to leave her in there for
Okay.
now, but just in case, is there a way we could put a third successor representative in?
Are we doing that right now? Not usually.
Well, yeah.
Right.
I mean,
so
but
so
here's the thing.
if that comes up, stepping out of character, if that comes up, raise your hand, ask for a site coordinator, and we'll do
and they'll
it.
make the call. Right.
All right.
The short answer is we can add. We can't do it in the question, but once we generate, when we get to the end of this process through Hot Docs, your documents are going to generate into Word, and your site coordinator can go in and custom add a third.
That's a pretty easy fix.
Just make a note that remember to go back.
Yeah. And the other thing is you could say, well, if you want to name her at the time that she would pass away, that might be a good time to be reviewing your estate plan anyways, and you could come back to the program.
So what I'm hearing is anytime there's a life change or life circumstance change, like a birth, a death, a marriage, a divorce, anything like that, I really want to review my estate.
You should always review it, yeah. I mean, the critical parts of making sure you come back in the program, if for some reason you and Megan got a divorce, get in as soon as you can, because that's a big deal. Otherwise, you've named her in your documents. Okay.
Perfect.
If you have the birth of another child, because we've provided in here, that should still take care of it. But you yourself should always be reviewing these on a regular basis. Good idea.
Thank you.
Okay. All right, we're going to talk about bond a little bit. I see that you selected that you don't want to require a bond, and that makes sense. A bond is going to be required only if you don't really trust the person that you've named to be taking care of your estate. If somebody says, well, I named this person, but I really don't trust them, then you really need to counsel them, find somebody else. I mean, think that through. If they really don't feel that they have anybody else, then, a bond could be required. You'll see where that comes up in the document. All right, let's talk about your kids and about guardianship and how you'd like to be taking care of the kids. So tell me a little bit about your thoughts first. And I usually have them just kind of explain it, so that way I make sure that what they're trying to say in the questionnaire is actually what's in their brain.
Well, I mean, obviously I want my wife to take care of our kids.
Mm-hmm.
If God forbid something should happen to me.
Uh-huh.
And if she's not around, I guess my mom.
Okay.
At this point in time, I don't really care for Megan's family, so I'd really want somebody from my family to take care of me.
Okay. So we can certainly go ahead and put that in. When you're talking about our kids, I know that you have listed your stepchild in this document, and you need to understand that even though you're naming your wife to be the guardian, remind me what's your stepson's name? Louis, right? Louis' biological mother is going to have first priority upon your passing.
Mm-hmm.
So you can't, I see in your questionnaire, what?
Just about a character for a minute. That's his stepchild.
Yeah, it's my stepchild.
Oh,
So
your stepchild.
yeah,
I'm sorry.
it's my
I'm sorry.
stepchild, so I'm pretty confident that Megan would take good care. But and Megan's the Louis' biological father is in prison, so no.
There you go, father. Sorry, her name is Sue. I get so
I
confused.
know. I made it very confusing.
Yes, you should. People will often say, "I hate my ex-spouse. I don't want them to have priority for my child," and you have to just remind them they still do. They still do. You can still name somebody, and you should still name somebody. That kind of remains to be seen about how that would work.
Unless you've gone through the court process and severed that other person's parental rights legally, but we don't counsel on how to do that or what that happens.
Okay, you have all that in.
I have Megan.
Megan is in, and then I can't read that far. My eyes are so bad right now. So
You want to nominate a co-guardian?
Oh, yeah. So co-guardian, some people will also ask about that. Maybe they want a sister in one state and a sister in another state. Okay, this is the guardian. This is the person who's acting as the parent. You can't necessarily have that situation. That would be a recipe for disaster. You could have successors. And sometimes people will want quite a chain of people that are listed, to take care of their kids. Co-guardians might be appropriate if it's a husband and wife. So that way, whether it's the wife or the husband that's going to take the child to school and register them, or they might just decide that they want maybe they want a sister, but not her husband to be the guardian, and that's okay. You can list that. It just means that on any legal paperwork, it's going to have to be the sister that's going to be signing, and not the husband. Does that make sense?
You'll hear some, and this is a client counseling point. Well, you'll have to decide for yourself how you want to counsel your clients. Personally, I counsel clients. Say if you have a husband and wife, it's your brother and your sister-in-law. If they go through a divorce and you've named them both as guardians, there's a potential there for conflict. But balance that against just naming your brother as the guardian, and now your sister-in-law can't enroll the kids in school, can't make medical decisions, can't, right? So all of these things. So that the client needs to balance the risk of divorce and a custody kind of dispute over the guardianship, or having only one decision maker for that child.
Age is another thing. I know he's listed his mom. And for a lot of folks, that's kind of their backup. They automatically think of a parent, but now you've just put maybe an 80-year-old in charge of a 6-year-old, and is that the right way to have it? Maybe it's convincing them that there are other people that could take care of the child and that grandma can still have an awesome grandparent relationship. But again, that first responder is going to know their own situation, and we'll respect that, but it's worth at least talking about it a little bit just to confirm.
Okay, I put in mom as second.
Okay.
Successor.
And then down at the bottom, you'll see as you're going from screen to screen, there's previous and then there's next, so that way you know what you're on.
Yeah, when you're finished filling out a page, you either Alt-N or click on next to get to the next screen.
Okay, so
or you can click over here.
We've designated different folks for different roles. Let's talk a little bit about where you ultimately want your assets to go. And we're going to talk about kind of 3 different categories. Specific request is the first one that's listed in your questionnaire. And you said you didn't want to make a specific request, and that's fine. Some people will want a certain thing to go to a certain person. So for first responders, they might say, well, I really want my badge to go to my son, or I want my badge to go to my brother, or maybe somebody wants a family Bible to go to somebody. Some things are smaller, and they're really pieces of tangible personal property. So we'll talk about how to handle that. If they want a house, or if they want a sum of money, or if they want a vehicle, then they probably would have filled that out in the questionnaire. It's very specific if they're wanting to do those things. Most times, I think I've had maybe one situation where I had somebody who wanted to give a house to somebody else that was different than the residue of their estate. So most people, when they're planning, they want the same people to be getting everything, but there could be these little offshoots. So,
do you want to talk about, so that the first responder will get a separate tangible personal property list. So if one of the things like the family Bible, the badge, the jewelry, things like that, the first responder can actually write those things on the tangible personal property list, and it provides them the flexibility to then say, well, my daughter got a great ring from her husband, so I'm going to give that ring to another child. So the tangible personal property list that they will get when they leave the program is where we typically direct first responders to put those specific bequests that aren't real estate, cash, cars, that type of thing. Cars can even go on the tangible personal property.
Does the will say per the attached schedule?
So
There's
it
language.
makes, the Arizona statutes allow for a reference to a separate list. So it's not as if to say all tangible personal property goes according to the list. It says I may prepare a separate list on which I designate specific items. If I don't, then the tangible personal property is controlled by the will.
And that is something that they fill out in their own handwriting. That's their
not
homework.
something we do.
It's not something
We don't do it. No, we don't do it. But when you print out the document, and there'll be a copy in your packet. When you print out the will, the very last page will be a tangible personal property list. So as you're reviewing the document with the client, then you can show them, this is what it looks like. This is your homework. Make sure that you fill this out. You write what it is you want to give to somebody and who you want to get it, and then make sure that you sign it.
The caveat is this is effective at my death. So if I want all of my stuff to go to my husband, and I put his favorite couch on my tangible personal property list, I want that to go to my son. Well, now I've just given away the couch. So, or at least my half of the interest in it. So you need to make it clear this happens at your death.
Mm-hmm.
So if you want everything to go to your spouse, don't use the list. That's only for things you want to come off the top of what's going to your spouse.
Yeah, good point about priorities.
Yeah, the will document itself, page 3 of it, says, I may choose to leave a written statement concerning the disposition of certain items of tangible personal property other than monies. So it's referenced right in the will, and it's actually the first item within the distribution of the disposition of the estate.
Just out of curiosity, is that a fairly common statutory provision
in other states?
In other states, yeah.
I think it is, yeah.
Different requirements.
Yeah.
Did you have a question?
Yeah, with the schedule attached, is the advice that they kind of say, well, what if I make the schedule and then 5 years from now, circumstances change, I want to change it. Does it come back through the program, or is it you can attach a new schedule?
You can attach a new schedule, and we do tell them that that's the one piece of the estate plan that there's not a lot of magic to, that they can replace it, but they can do something in a similar format to what this is, and to use that as their guide. But that's the only thing that they could be writing on. So yeah, if somebody makes you mad, you just cross them off and you put somebody else on there.
That's the beauty of the list.
That's right.
Doesn't need to be notarized.
Right.
It just needs to be found within 90 days of the person dying.
And should be dated, because if you have a list and neither one has a date on it, well then what do you do? So it needs to make sure it's dated, and there's a place to date it. It's a very effective way to transfer stuff. And I'll tell you, when I was in private practice, the things that always make people fight in the States are dad's tools and mom's jewels, or any other little random thing. I had people fighting over hand-painted bird wallpaper one time. It didn't matter the huge chunks of money that they were going to get. It was this bird wallpaper, and I'm like, really? So, providing a list. I don't know that the bird wallpaper ever would have gone on the list, but for things like jewelry and sentimental things, and this doesn't just have to be family members or people that are going to be included otherwise in their estate plan. If I collect Coach purses and I want them to go to Trisha, then I write Coach purse collection and I give them to Trisha.
I want that Coach.
Okay, Sue.
Sue looks good.
So it's those kinds of things that can be helpful, and people can continue to attach pages. So spend some time talking about that list, because that's one thing you can really benefit the client by explaining how flexible that list is and how that will help to facilitate the estate administration.
And is the advice on describing the items just as, specifically, obviously if it's a card, maybe like a good idea to write down the VIN number, but if it's like family jewels, like
you better be specific.
You better
be
mom's
specific.
ring.
My advice is to act as if someone you don't know is going to be coming in and picking out that item.
Right.
So describe it in such a way that someone who's never been in your house before could say, "Oh, that's what he meant."
Mm-hmm. Some people will even take pictures and they'll attach. They'll write a good description on it, but then they'll have a photo, and that way they go, "Oh, that's what you were trying to describe through that." As long as it's kind of cross-referenced in there, that's a good way. Not just leaving a picture saying, "Give this to Lisa," but just coordinating that. The more instructions you can give to the people that will be left behind, the better it will be.
Now we're on to
So
the rest of it.
All right, so let's move on to the next part. You'll see, these next several pages in the questionnaire are going to look pretty similar. So we're going to talk about tangible personal property. That's your stuff. And there are a lot of choices that you had on this page, and I'm going to just kind of walk you through a few things. I see that what you've selected is that you would want your stuff to go to your spouse, and then if she's not living, you want it to go to your then living children.
I didn't really understand that part of this.
Yeah,
I mean,
it's confusing.
So maybe you can help me understand between that and Persterpes, which
Right.
kind of sounds like a disease.
It does sound like a blood disease. Persterpes just means by bloodline. So at that point, I usually draw this little chart, which is, easy breezy, right? So Persterpes means that if something happens to one child, you've got 3 kids. If something happens to this child and this child passes away and that child has a child, then it will continue by bloodline and go down to this child. If you only pick my then living children, then it's kind of a last man standing type of provision. So only the 2 children would receive everything, and the descendants of that 3rd child wouldn't receive anything. So I'll tell you, it's a pretty common thing that people don't select it because they don't know what it is, but as soon as they find out what it is, that makes sense. So is that what you would want, where assets would continue by bloodline and go down to your children or grandchildren if you don't have, if the child has passed away?
No, I want Persterpes.
Persterpes? Okay.
So for the benefit of people who can't see this chart, so Persterpes, if I have 3 children and my one child has 2, which is my current family situation now, so this child has 2 children. If Emily dies before I do I want her share to go to these 2 children, or do I want her share to go to these 2 children? So I would create 3 shares, regardless of who's alive, and then determine what happens to each of those 3. Again, go down Persterpes to the deceased child's issue, or go to the then living children, last man standing. And only when all 3 are gone for the then living children would these 2 grandchildren inherit. Does that make sense? And Denise has a nice chart. I don't know that hard to see.
I don't know that it's that nice, but yeah, if you look into your materials, when we're talking about tangible personal property and personal effects, it shows client, child, and then grandchildren. But usually you draw this chart one time and you leave it at your desk when you're counseling the clients, and then the next client that comes in, then you say, here's what this looks like, and then you can do it. Or you can just redraw it depending on how many kids they have. But once they understand it, then they usually, not always, but usually will select it. So your wife is going through the program today. If you want to go and let her know that we've had this conversation, you're absolutely welcome to get up and go over and talk to her. Her attorney's probably telling her the same thing and explaining it, but you're welcome to get up and go over there and talk. And I'll invite them to do that so they don't feel like they're just stuck in their seat. And again, because the program kind of marches along similarly in time, that spouse is probably going through that same client counseling point right there. Then they just have the comfort that, that's what they've chosen. Doesn't mean they have to.
Right.
Doesn't mean they have to.
Well, she's staying with then living children, but I really want Persterpes. Does that matter? And I say, no, you can each have your own will. Your will controls your property. So in a community property state, you each have a half interest. So if you die together, her half goes then living children, your half goes Persterpes. Or if you survive and you inherit it all, then all of it goes Persterpes. So you can have different provisions in your will.
Now,
So what I've been doing lately in practice is, for this question, for the tangible personal property, I just go to the default of to pass by the remainder of the estate, and then under the remainder of the estate, I list what the first responder or spouse partner really wants, which is in this case Persterpes.
most people will want their stuff to be distributed according to the remainder of their estate.
That's everything that's left over after the specific bequests have been distributed.
And in documents in private practice, you'll see that tangible personal property is always dealt with separately from the remainder, and there's a tax reason for that that doesn't apply here.
Yep. All right.
So
we're through that, and there are minor children that are named as beneficiaries. I kind of want them to get them when they're 25. Can I do that through this program?
no, actually, it's either 18 or 21, and the reason is there are certain types of accounts that can be set up either at 18 or 21, but not necessarily in between, and not over that amount. Now, if you had extremely strong feelings about wanting to postpone the age when your children are going to be receiving, that's outside of the scope of our program, but you could go and you could meet later with a private practice attorney and talk to them about setting up a separate trust that would replace parts of your estate plan for that purpose.
So 21, please.
Okay, we'll do 21. So you just click the box, and again, that's going to bring up the information. So those are all the questions that you have to fill out, and so I'll just let you talk through about working through the witnesses and things like that.
When you get to your table, so you have a drop-down box to choose the county where you're sitting on that day, where the documents are going to be signed. Typically, you'll be in Maricopa County, I would imagine, unless you want to travel to other counties. We welcome you there as well. Execution date, the date we're going to sign the documents. I always love saying we're going to
execute date.
So we can execute today.
There's another shortcut to that if you delete that, Tricia. Just hit T and enter, and it automatically populates the date.
I'll never remember that. When you sit at your table, 10 years and I still don't remember that. You'll have the names and addresses of your witnesses, who will be your particular witnesses for the morning, and then you'll get afternoon witnesses. We have volunteers from the law schools, and they'll rotate. So we typically have 3 witnesses at each program, sometimes only 2. Or excuse me, did I say witnesses? 3 notaries, sometimes 2, and then 2 witnesses with each notary. So you'll know who your witnesses are, so you can type in their names. Now we're at the end of the will interview. And as you'll see again, down the left side of the screen, every little mini box over here shows all blue lines. I don't have any grayed out boxes. I see here I have 0 unanswered questions. So I can do one of several things here. I typically click finish. I click save, but before I click finish, I always go back up and I save my answers. And it's the box with an A. There's another save here that you don't want to hit. You don't want to save the document. You always want to save your answers when you're in Hot Docs. So I haven't generated my document yet. So then I click finish. And this should pop me over into Word and give me my will draft. Hey, I love it when things work. So now I have the draft of my will. I always save. Where's my mouse? I need a mouse pad here. I go up first thing.
Yeah, don't worry about it. Just save the document to your.
How do I get out of this box?
That's probably it. Escape. No,
escape's not working. Just work
there.
Okay.
Yeah, just save it to your desktop, just in case again the computer crashes, or save it somewhere in the computer and we'll delete it later.
I forgot this isn't our laptop. I can't save it.
So now go ahead and go back down to the little D.
And then down here it shows me what programs I have running. So I go back to Hot Docs.
And then double click on the General Durable Power of Attorney. And what you'll see is instead of doing a new answer file, there's a drop down right there. And you click on Arrest. And hit OK. And some of the information will automatically populate so you don't have to retype it. So here you already have the client information already up. Now you get to go through the agent information as to who's going to be the agents for the General Durable Power of Attorney.
So we're going to go ahead. We've done the questions for your will. We'll go over that and actually go through the actual document in a little bit. But we're going to go through the questions for your General Durable Power of Attorney. This is the document that's going to give financial power to your agent. Very powerful document. They can financially be you, or that person can financially be you. So I see that you want your wife, Megan, to be your agent, and we're going to go ahead and put her information in. And then I see that you would like for your mom to be a successor agent, so we're going to go ahead and put that in as well.
So now I know you asked for an address, but like she's moving,
Uh-huh.
so do we really need an address?
Still put an address in there, but I think the key these days is to have a phone number. Mm-hmm. So we'll put in her current address. You don't have to necessarily come back through the program to change an address, but at least it shows where she is at this current time. Is that the way you would counsel as well?
Yes, and I've also told people, you don't have to come through the program. You can just put a post-it note if the address has changed and you want that on your document. Don't write on the document, but just put a post-it note for someone who's grabbing your document.
With their current
who the
contact.
agent is.
Just go ahead and pick an address.
And then the other thing we'll talk about is when this document is going to become effective. Just make some notes. There are two options. One is that this can become effective immediately, which would mean that it would occur today. So that Megan could actually take the document we're going to prepare, go to the bank, and that particular bank account that just has your name on it, that you don't have with her jointly on it, she can go and she could actually withdraw all the money from that account without you being there using that document. That's effective immediately, happening today. Or there's an option for a springing power, and that just means that when you can no longer handle your financial affairs, that the power for her to act would be springing at that point, and that's when two doctors would declare you to be unable to handle your financial affairs. Do you have a preference, or do you have more questions on what that means?
No, thank you for explaining that perfectly. I was confused about that when I was looking at it. I can't imagine why you would do it on the date of signing effective immediately, but I chose spring.
Springing is, yeah, that's fine. And again, you know, you could get different answers. If you have somebody that's just brand newly married and they say, let's have it be effective immediately, I might counsel, you know, a lot on that point about why you might not want to have that be the situation and that you'd rather have it to be a springing power. But again, take it as it goes, and if you're not comfortable having the conversation, just raise your hand.
Again, Trisha's saving the answers, and you want to, you want to go back because you missed the date notarized.
So go show where that, show how that.
It doesn't show as a missed question.
Oh, it did. Okay.
Yeah, I'll talk about that. But the date when notarized. Yep. Hey, remember. So the witness information is already populated. You don't have to re-enter it. You just hit finish or last, either one.
Get a mouse pad. I got this.
And again, you want to save the answers because the answers changed. And there's your general durable power of attorney. One thing you'll notice about this document that's new, go ahead, Trish.
Well, on this one, so if you go back up just a little bit, okay. A couple things that I do that are not going rogue with the document. You know, I look at the address for the agent because sometimes that just shows up sort of written funky. So I make sure that this street is on one, and then I'll hit a tab or a return to have the the city and the state underneath. What? Yeah, and then I thought you said comments. I'm like, why am I deleting my comments? But yeah, delete the comments. Anyways, I just do that. It's just, again, we want it to look like a document that just looks professional. So those are some little things that I change. Here's the important part of this particular document. Based on the conversation that we had on when this document is going to become effective, determines what box is going to be checked on the left hand side. Effective date, the powers granted to any attorney in fact herein shall become effective either upon date of signing, which that box should check if that's what he wanted, or upon incapacity, excuse me. They do not initial anything when you're going through this document until they're actually with the witnesses and the notary. But at the time that they do sit down with the witnesses and notary, then they'll initial in the box underneath there the appropriate selection. Okay, so some people might think, well, maybe I should do it right now. No. Don't have them sign anything, initial anything, do anything until they're actually sitting with the witnesses and the notary. But that's a newer change to the program. We used to just have everything become a springing power, or have it be a springing power, and that's something that we revised the templates to give them the option on that.
And then you go down to the date, and you go back into that template list. You double click on healthcare power and living will. You select, using the drop-down, arrest, or whoever it is you were working with in front of you. Hit OK.
You can operate a mouse.
And it
better than I am.
automatically populates, again, the critical information. But here, what's different is the final arrangements.
Right. So I see in here that you've listed that you want a healthcare power of attorney and that you want your wife to be named. You also want your mom to, Amber. That's a different name. Who is Amber? She your sister?
Yeah, she's my sister. She's
Okay.
a nurse.
Oh, okay. So the important thing is that if you're going to be naming Amber as a successor, having the conversation both with her, also separately with your wife, about what you're really wanting to have happen. What are your thoughts on different procedures? Because if you're not able to act and this person's acting, they need to know what you want. So it's really important to let people know. And the same thing on the final arrangements. Have that conversation too. I see that you want to be cremated.
Well, what I really want is a Viking funeral. So can I have that? Can we put that in?
That's an interest. That's exciting for you and very unique of you. I don't know that we can really list that in there. But you could always say final arrangements have not been decided, and you could have a conversation with Megan or with your sister about what you'd want to have happen. You'll notice that we have it in here and it's not in the will. The reason is people don't always look at the will until sometimes somebody is buried or cremated or time has passed, and then they look at the document. So we tell them it should be in the medical power, because usually in those end-of-life situations somebody might be acting, and that's why we've got it in there. But this is a really important conversation for you to have, and let them know what your thoughts are.
Thank you.
So are we doing cremated?
Cremated, yeah, let's put cremated, fine.
Oh, and then on your questionnaire, you don't have her complete phone number.
Yeah, so I don't remember what her number was, and I can't find it in my phone. Is that important?
It is actually important because that's the first line that somebody's going to be, going to be contacting. So what I might recommend, maybe you could call your mom. We can, I'm going to type in some more information, but if you want to take a minute and call your mom, I'm suspecting she might have Amber's phone number. It is a very important piece because that's going to be how they're going to contact her if they need her.
Okay. And again, we put these little Easter eggs in here because we wanted to make sure that you knew that these are issues that come up with some frequency.
Yeah.
So that's why. So pick a phone number. Amber lives on Fifth Amendment Avenue. Fifth Amendment Drive.
Of course she does.
Of course she does.
Okay, we're going to move on to the next document, and this is a living will. This is the document that has an interesting name. Most people think a living will would mean you'd want to live forever, but a living will is actually the document that gives directives directly to your doctor saying that if certain circumstances have occurred and you're in a terminal
condition
or irreversible coma or persistent vegetative state, that you don't want these things to occur. Okay, you might be familiar with the Terry Schiavo case from many years ago, where the woman didn't have a document like this and didn't provide any instructions on whether she wanted to be plugged in, not plugged in, etc.
I remember that.
Yeah.
So yeah, I definitely want one. Yeah.
Okay, so then here's, in counseling through this one, I find it a little bit tricky, and I really focus on the questionnaire as opposed to what's on here when I'm walking people through, because what you need to remind people is that this living will, as long as the person is able, is not in this persistent vegetative state, irreversible coma, that, these first responders, they know they still have the responsibility to go in and give medical care and take care of this person. It's only if they're in that situation that then these other selections really apply. And then these are very personal decisions on whether somebody would want to have food and hydration, whether they'd want to have CPR or electric shock, whether they want to stay at home for their care, end of life care, whether they'd want to get medication that could hasten the moment of their death. That's just morphine that can actually shut down organs. And then for women that you're counseling, if they are known to be pregnant, would they want to be sustained to the period of time that maybe the baby could be born. So each of these is a very personal discussion. By clicking the box, it will show up in the document, and I encourage you to actually take a look at the completed document in the packet to have a better understanding of how all this stuff reads. And you'll walk them through it, but then you'll give them time to also sit down and read it too.
Especially with the first box, artificially administered food or hydration. That's usually the one that people are most anxious about. They will say, I don't want to starve to death. So you might want to counsel them around that.
Up on the screen you'll see, and I don't know if we're going to either taking it off of the interview altogether or adding it to the questionnaire. First responders will ask you, what's the difference between this and a DNR? or maybe they won't ask you. But I'll tell you, there's a do not resuscitate order is something that you complete with your physician. If typically you're going to be in a terminal condition and the physician counsels you about what a DNR is. It's on orange paper and it goes in your medical file and no one can overwrite it. You will not be resuscitated if you sign this and it's in your file at the hospital or at hospice. You typically would see it in a hospice situation. So the living will is not the same as a DNR. Your healthcare agent will be, the way that these documents are put together, your healthcare agent will be the one enforcing your wishes under the living will. The doctor won't be overriding the agent and saying, no, I have this living will and it says X, Y, Z. It's not like that orange DNR, whereas if you had an orange DNR and you're saying, put this person on a respirator, the doctor would say, no, I can't, I'm legally bound.
And we don't do the DNR.
We do not do DNRs.
That has to be a doctor that does it. Yeah.
It's a physician.
Oh, okay.
Some of the first responders would be familiar if they're going into an elderly person's home, they might see one magneted onto the refrigerator. I mean, like that's a place where somebody would actually keep it. If it's not in the medical file, like it would be very prominently. And older folks that have them, they'll tell everybody that they've got them.
And that's it. You should be done.
Excuse me.
The date when signed, hit finish, and it will again ask you to save your answers. And there's your healthcare power of attorney and living will. You'll print them out. It'll print wirelessly to a printer that's dedicated for this program. You'll go get it, bring it over, and sit down literally and review the documents which are produced, copies of which are in your packet with the first responder. And if everything looks kosher and they're happy and everybody's name is spelled right and there are no asterisks around if-then statements, and they're done and they don't have any other questions, say thank you and ask them to go over to the notary table and or if there's a line for the notary, just ask them to kind of get in line and the notaries will take care of them. The notaries know they have their own execution script, they have their witnesses, they'll sign, execute, date the documents, and give them, staple everything, put it in a nice folder and send them on their way.
There's a chance that if something happens while they're signing, if the person signs on the wrong line or whatever, they might come back to you and they might need another copy. So for me, I usually, obviously you save the answer files and save the documents, then you can go back to it. Depending on the flow of people, I'll either, take that time to kind of get ready for the next appointment, or I might take somebody else, but there's always a chance that you could have to go and reprint it. If it's at the very end of the day, we'd ask that you don't shut everything down until all the people that you've worked with have actually gone through the notary station and have actually left for the day.
And for your own, as you're looking at the will document, the paragraphs that you impact by your input, if you want me to walk you through those, so that you know what to spot check. Obviously, the first paragraph, Article 1. All the family information.
And when I'm going through that paragraph, I'll, again, I'm sitting there, I won't read it to them. I'll ask them to look at it and to read it and to make sure that I've gotten the spelling correct, that I've gotten the birth dates correct. And so that's a very important one.
On page 3, paragraph B, that's your remainder of the tangible personal property. That paragraph A references the separate list, and that's just the standard. It won't change. Paragraph D, take a close look at B and D and make sure there have been times where we get glitches in hot docs and it may not be consistent, where you may see your sentence just dropped off, where you see, I want the remainder of my estate to go to, and the text is just gone. So just make sure you eyeball that it's correct. Paragraph E, ages, that you impact that. It should match paragraph G. On bottom of page 10, subparagraph D of paragraph G, talks about the bond. Oh, I'm sorry, page 5. Talks about the bond. Read that. Oftentimes, I get it backwards. The questionnaire and the interview, the questions aren't exactly the same, so just make sure you waive bond if that's what you intended. Bond is waived again on page 6, and you impact the paragraph above that by identifying the name, personal representative. If you have a disinheritance, you will see language above Article 4 in paragraph H, that language will change if you have a disinheritance.
Do you go through the final product line by line usually?
Yeah. I generally go article by article, but these paragraphs that I impact, those that we talk about, I talk about specifically.
Yeah, so like for Article 5, where it says powers of personal representative and trustee, I'll just reference that this is essentially standard language that's used in many documents that outlines what the powers of the personal representative are, what they can do, and I'll ask them to review it at a later time when they're comfortable.
But I'll explain that this gives very broad powers to allow the personal representative to do everything that's necessary to administer the estate. So they have the gist of each of these paragraphs.
Just kind of give an overview.
But on the ones that Trisha's pointing out, again, because they're impacted based on what we put into the system, we'll walk through those.
Article 8 is guardians. And then
All right. I'll always sort of explain what Article 6 means, simultaneous deaths, because that can be confusing for people.
Yes.
So I'm sorry, Article 8, guardians.
Right. And then our witness names and our person signing, check all of those. But those are, so there's a lot of stock language in here that you don't impact, but that's not to say you shouldn't walk through it with your client. It's just take a closer look at the paragraphs you do impact. And if you recall, when you're in the Hot Docs program, if you take a look at that document preview, all of your inputs will show up in blue. So if you wanted a quick, easy, okay, what did I impact in the document, you can go back to that document preview and see where your inputs show up.
Question about the simultaneous deaths. Isn't there like a period of time that pertains to?
So we
over 24 hours or 48 hours or some sort of
120, but we overwrite that. We say we don't want the statutory presumption to apply. We want, if there is a death where we can't determine who died first and we're not going to the 120-day survivorship period, that presume that I survived my beneficiary so that my will controls. That was the policy choice we made in the document.
Should we expect that each first responder will want to fill out all three of these documents, or is it common that they just do one or another?
95%, maybe more.
Under 20 hours.
95% or more will want all three documents.
Once they're explained to them, like they might not think that they want a general durable power of attorney. They might not understand what that exactly is. I would say that maybe the only one that I've seen is maybe they don't want a living will.
That would be the
and I don't necessarily see that choice from the first responder as I do from the spouse or partner of the first responder. Most first responders who have seen, what can happen when these people are in this situation, they'll say, "Oh yeah, pull the plug, I'm done." It might be a spouse or partner that says, "No, I'd rather not have a living will because I want to be kept alive at all costs."
And if they say I don't want a financial power of attorney, I signed one 5 years ago with an attorney.
Yeah.
The counseling point there is the closer in time you are to the date you sign the document and the incapacity, the more likely it is I'm going to get Chase or Wells Fargo to accept that financial power of attorney. If it's dated, if it's 5 years, 10 years, 15 years old, it's less likely that I'm going to be successful in using that in incapacity. So even when I was in private practice, if a client was coming in to amend a trust, had nothing to do with their powers, I always had them sign new powers just so that I had fresh documents.
And so before you start doing anything, you probably sit down with the client or the first responder and give a general overview of each different document and what they do. They probably are familiar
I either do it at the beginning or as we're going through the questionnaire. Sometimes I just kind of get the information, or I'll look through, and if I've seen, when I first sat down with them and I say, just give me a moment to look through your questionnaire. If I see that they don't want a document, I might have that conversation then. If I see that they want all the documents, then I'll kind of truck through and discuss again what that document does when I'm putting in the information.
Yeah, that's very much style over substance, whatever you're comfortable with. All right, if there are no other questions.
Ask one more question.
Yeah.
People will they ask for continuing dialogue with you? And if so, if I have questions about my will after I talk to my spouse, you just refer them back to call.
Yeah, you're not allowed to have a continuing dialogue with you. If they ask you, say, hey, I want to send you a thank you note or something, just to, that's fine. I don't have a problem with that. If they solicit you for something, I don't have a problem with that. The program doesn't have a problem with that. But if they want to have a continuing conversation with you about their documents, absolutely not. That would essentially trump the limited scope representation disclaimer. So, yeah, or just sort of, drill down a little bit more. So I'm happy to, but can I ask you why? If they say, well, just in case I have any problems with that, you can say, well, look, the program doesn't allow me to do that. I can have the site coordinator come over and explain that to you. But if they say, I just want to send you a little thank you note, then say, sure, here's my info. So that's cool.
And the way the experience from the first responders perspective, they schedule their appointment with a contact in their own department. So they're not actually interfacing with anyone with our program. We have someone who coordinates with a point of contact in each department, and then that person's responsible for getting the questionnaires out, getting appointments booked, getting us a facility, all of those things. So you can always say to the first responder, well, who did you schedule your appointment with? Go back to that point of contact and find out when we're coming back through, and you can, if you and your wife discuss this and you want to make a change, go back, and next time we come through, you can schedule an appointment.
The one thing that, they don't know who they're going to be meeting with until they show up that day, but do know when you sign up to be there, there will be a first responder that is designated to be meeting with you. So, if something comes up and you go, oh, I just can't, and it's the Friday night before, there will be first responders waiting, to be meeting with an attorney that was in the slot that you had signed up for. So just be very cognizant of that. Schedules change, we get that. But certainly letting people know and getting back to the site way in advance if your schedule changes, as opposed to, oh, I'll get to that later and then go on and take my name off the list. Do it ASAP, because people will be counting on you. And we're counting on them to show up too. It's disappointing if you had 10 spots for first responders to come in. If 2 don't come in, then you're thinking, well, now we've got an attorney who's sitting there, and that's not respectful of your time. So we've put that out there, and the department heads, they know. And we've had some, if somebody's not showing up, man, they're on the phone like, hey, man, you said you were going to be here. There's an attorney who's waiting for you, and you're not here right now. So they take it very seriously.
We actually had a fire truck pull up with people on duty, and they said, okay, we have some open spots. So,
because there's a waiting list. Yeah. So.
If we're asked after, we print out the docs and send them to the notary table, like they're like, oh, where do you recommend I keep these? What's kind of a good response to that?
Somewhere fireproof.
Yeah.
Like if you have a safety deposit box or...
That one's tricky.
That's hard.
So the safety
deposit... they would only have access to it.
Right. A chicken and an egg. I'm the personal representative. How do I prove it? Well, it's in the will that's locked in the box.
Just somewhere fireproof and let your loved ones know where it is.
Let them know where it is. For the medical powers of attorney and the financial powers of attorney, photocopies are sufficient when somebody's using it. They don't always have to have the original. And so, having multiple copies, maybe giving multiple copies to the agents is a helpful thing. If I'm in a car accident and my spouse is with me and that's the person who I named as the agent and my dad is my backup, I need for him to have my document, as opposed to him going, God, where does she have this stuff? So making copies of those documents, I think, is very important. It is sort of challenging on where do you actually keep the will. If you're going to keep it in a safe deposit box, then you better make sure that the person whose name is jointly on that box. Otherwise, that's just challenging as all get out, and the people know where the key is and that.
One of the things I've heard is that when you tell someone they can make a copy, is that you should tell them to flip the page back instead of taking the staple out. Is that relevant or not really?
That goes back to when we glue back documents, so that if you just flip the page and you don't unstaple it, then it's the document's integrity is intact, so that you have a split page something. So I think that's good advice. I glue back originals for clients.
Power of attorney instruments are probably less of a big deal, but on a will, that would be the one that I would probably just say, flip the page and just make the photocopy that way. And or maybe even write on there, original this is a copy, the original is, and list where you're keeping the original can also be a helpful pointer. Again, anything you can do, or counsel the first responder to do, so that people know where the stuff is good. We're in 12:05.
Yeah,
we
so
can stay around and answer questions, but I know you guys also have things on your schedule too.
So thank you, everyone. Thank you for coming.
Yes.
Thank you for volunteering. We look forward to seeing you at a future event. And again, thank you to Ballard Spark
Yes,
for
thank you.
hosting us.
Thanks for coming.
Thank you.
All right, thank you. Have a good day, guys.